In order to address concerns surrounding this public health emergency, the court has had to modify how it conducts our oral arguments. We're now proceeding, as you know, with oral arguments via remote video conference, which will be live streamed for public access. The court staff have made every effort to prepare us and counsel, but when the inevitable glitches arise, as they did this morning, we will all need to exercise patience with this new technology. So I thank you for your patience. And as I mentioned, the public may view the arguments in real time at the DC Court of Appeals YouTube channel, which is on the court's website. So with those introductory remarks out of the way, we have three cases on this morning's calendar. The first case is 1305 Rhode Island Avenue Northwest versus John D. Muscles. Counsel, you may proceed.
Morning, Your Honor. Robert Gill for the appellant.
Go ahead.
I'd like to reserve 4 minutes of my argument time for rebuttal, if the court please. As the court knows, this is a TOPA case, and there's a dispute over real property located in Washington, D.C. at 1305 Rhode Island Avenue Northwest. It was a single-family property. It was divided into a 4-unit rental accommodation. The tenants in the property exercised their TOPA rights in 2 ways. One, there was an effort to effectuate their collective TOPA rights through a written expression of interest provided by one of the tenants who was acting for all the tenants, named Arian Attar. And that expression of interest delivered to the Department of Housing and Community Development within the statutory time frame of 15 days. After that, another expression of interest sent by one of the tenants individually by the name of Bridget Morstad. And that expression of interest was also timely provided to Department of Housing and Community Development. And both of those expressions of interest were similarly provided to the owners of the property as required.
Mr. Gill, if I may interrupt you, just a quick factual question.
Yes,
Is there a factual dispute as to whether the collective statement of interest was actually received by or provided to the department on August 31st as opposed to September 1st?
No longer, Your Honor. There was at one point an issue over that. That was a point that was conceded before the trial in the trial court.
So that is no longer in dispute.
That is no longer in dispute.
Okay.
So could I just get a clarification on that?
Yes, sir.
Is the point that was conceded that it was placed, in the DCHRA mailbox on August 31st? Or did they concede that somebody, a representative of DCHRA, actually had this notice in their hands on August 31st?
I don't know that the stipulation was as specific as Your Honor.
Do you know what it?
Only specific as to the date?
It was very specific as to the date. It was specific that it was actually received on August 31. Actually received.
Actually received. I have another factual question. You mentioned that the owners, both expressions of interest were sent and received, sent to and received by the owner, right?
Yes.
How were those sent?
Well, that question addresses one of the central issues of the case. The individual expression of interest sent by Bridget Morstad was sent by certified mail, and there's no question that that was timely. The expression of interest that was sent collectively on behalf of all the tenants was sent by United States Postal Service priority mail, not sent by certified.
To both the owner and the department?
Yes, ma'am.
Thank you. However, yeah, okay.
Yeah, so that is one of the issues in the case, is where you have an expression of interest collectively on behalf of all tenants that was otherwise valid, and it was timely received. If it was sent by United States Postal Service priority mail instead of certified mail, was it valid? And of course, the motions judge below, Judge Kravitz, decided that it didn't comply with the strict requirements of the statute. Our position is that that is a hyper-technical requirement for a statement of interest that was, at this point, it was agreed, it was actually received by the Department of Housing and Community Development and the owner within the 15-day period.
So, so if you look at the language of the statute, which refers to providing, I think the word is provide, right? Provide by hand or sent by certified mail.
Yes.
Right? Clearly it was not sent by certified mail. So is your argument that this was provided by hand within, that we should so interpret the statute?
Well, that is, I think, part of the issue here, because I'm aware of the history of the statute as well. The statute used to just provide or require that a statement be provided without specifying how it be. And I know that's the issue that the court had dealt with in the past. Then the statute was modified to provide for the by hand or by certified mail. But that's exactly right. I mean, what exactly is a by hand delivery? We know that by hand delivery is not electronic delivery. But on the other hand, if you have a letter carrier that is delivering the document by hand, then that's arguably in compliance with the statute. To me, part of my argument is that under the statute, which of course it's clear that TOPE is remedial in nature, and the overarching purpose of the statute is to protect tenants' rights in rental housing, then, you know, where you have this expression of interest that's timely received, should it be invalidated on a technicality? And in my view, it should not be. Particularly here, the facts of this case show that the tenant who sent the expression of interest, Arian Attar, was actually a law student and who also sought counsel from the tenant advocate for guidance on how to express the expression of interest and how to act on behalf of all tenants. If this is a technicality that a law student who has sought counsel from the tenant advocate can't do in a way that's going to be recognized, that's a trap door for the exercise of TOPE.
It's not so hyper technical, counsel. It is a plain reading of the statute. I mean, it's not confusing. It says delivered by hand or send it by certified mail. It's not a trap door. You don't need to parse a lot of difficult language to figure out that requirement, right?
With due respect, I think that it is specific with respect to the certified mail component, but I don't think the part about hand delivery is clear at all. We've seen other requirements where there's a requirement for delivery by hand. I mean,
I just want to separate out two different arguments you're making, because one of them I take to be a perfectly good argument, and one I don't think is so good. One is sending something by mail that gets there within the statutory time frame constitutes delivery by hand. Fine, like I get that argument.
right.
I think Judge Ruiz was suggesting that one to you. Another one is, you know, even if this doesn't satisfy the by hand or certified mail requirement, it would be hyper technical to enforce that statutory requirement. That one I'm not so sympathetic to. So I guess I might be nudging you toward the first one a little bit.
Well, and let me be clear too. I'm not taking the position that if a tenant provides an expression of interest and they don't do it by certified mail, and they send it by other form of mail, whether it's regular mail or priority mail or some other form of mail, and it doesn't arrive within the required period, I'm not saying that's valid. And as a matter of fact, I'm going to rely on language from this court's opinion in Tippett, which I'll refer to as Tippett 2, which was a 2010 en banc decision, where the court said, nothing we say in this opinion precludes the tenant from sending a statement of interest by mail. But he simply needs to make sure that the owner receives it within the 30-day period. In other words, the tenant who elects to use the mail accepts the risk of delay. And I think that's exactly the case here. If it's actually received by whatever method, I think that's valid. If you're relying on the mailbox rule, you need to strictly comply with the requirements of the statute. That's my position.
Because in Tippett 2, the court basically defined or interpreted provided, the statutory term provide,
Yes.
as meaning delivery.
That's
actual
correct.
delivery. And you're saying, so provide by, it's just, and what the council then did was to, as you say, amend the statute to add the mailbox rule as a way of, in essence, that could extend the time of delivery, so
Yeah.
long as it is mailed within the 30 days by certified mail.
That's
And
exactly.
that's what tells you that you in fact complied within the statutory period.
That is exactly right. That is exactly right. And, here, I think that the actual delivery point is one that to me is critical, particularly given the facts of this case, where the expression of interest came from a law student who had sought counsel from the tenant advocate. To me, those are all relevant points. I'm also aware that at the time the statute was modified, from the just provided language to the specifics of doing it by hand or doing it by certified mail, that the purpose of that was to provide a finality for the owner. So the owner wouldn't have to wait forever, because previously there was no time limit for the expression of interest. And so there was a balancing of interests, but nowhere in the legislative history have I seen any indication that there was an effort to make a trapdoor, if you will, so that if there's a technical glitch, it's going to be invalidated. Now, the invalidation point is something that ties into the individual expression of interest, one of the other principal issues in the case, which is the validity of the individual expression of interest that was provided by Bridget Morstadt, one of the other tenants. It's absolutely clear on this record that the provision of that individual statement of interest by Ms. Morstadt was timely and provided by certified mail in accordance with the statute. The only issues that have been raised in this case by the appellee concern whether or not you can have an individual statement of interest if there was a collective statement of interest. And to me, the obvious reading of the statute is that if there has been an effective statement of interest by the tenants collectively, then that is what is effective. And if the tenants collectively don't submit a statement of interest at all, or if it's ineffective, then it provides the window under TOPA for the individual expression of interest. So to me, our argument is really twofold. Either the collective expression of interest is valid, and we'll get to the last issue of the assignment in a minute, or alternatively, if it's not a valid collective statement of interest, then the individual statement of interest by Ms. Morstadt was valid. But I don't think we could use a prospective invalidity of a collective statement of interest in order to then invalidate the individual statement of interest of the tenant, because I think that's another trap door under TOPA that doesn't square with the legislative purpose or the statutory language.
I want to ask
Mr.
you
Gill,
about that second one.
last question.
The individual, sorry, the individual one, and the fact that it's supposed to come after, or if there's been a failure to submit, right, which is the statutory language.
Yes, ma'am.
How does one, obviously there's nothing submitted very clear that the tenant's rights are, individual tenant rights are triggered. And I suppose that there might be cases where if it's, I suppose, let's say that the tenants collectively send an expression of interest that is clearly untimely, right?
Okay.
It's only sent by certified mail and it's not actually delivered within the 15 days, and the certified mail was sent outside of the 15-day period. Then I can see that you would say, yes, the individual tenant's rights are triggered because there's been a failure to submit. In this case, the determination of the invalidity of the collective, of the joint tenants' expression of interest wasn't really decided until this litigation, right?
That's correct.
In fact,
But to
it's
me-
still in the air right now.
Well, yeah, that's true. But I think the timing of the statements of interest is critically important, because the record establishes clearly that the collective expression of interest by all the tenants was timely and submitted within the 15-day period and actually delivered. And then the individual statement of interest that came from Ms. Morstadt came the first day after the 15-day period. So she testified at trial that she did that as a backup, and her testimony was expressly credited by the trial judge. So I think the record here, pardon my using this expression, is perfect for the alternative arguments, because the first expression of interest was timely, the individual expression of interest was timely. If for some reason the collective expression were invalid, then I think it's the perfect foundation for the successful application of the individual expression.
Mr. Gill, you've gone a little bit over the time that you had for your initial argument. We'll give you a few minutes for rebuttal. Let us hear from Mr. Crickman.
Hi. Good morning, Your Honors. If it may please the court, Kenneth Crickman for the appellant. Unless the court has any initial questions, I'd like to address a few points that Mr. Gill made.
I think I have an initial question for you. If the owner of this property was satisfied to deal with the tenants, having received their collective statement of interests, why is it that the third-party purchaser, your clients, have, I'll use the word standing, to complain about the timeliness of the filing of the collective statement with the department?
Well, I don't think the owner's satisfaction is really relevant where the tenants didn't properly comply with the statute that would invoke their rights to purchase. And I really don't think the owners haven't had an interest in which party buys the property, as long as one of the parties buys the property.
So why is it the owners can't waive the tenant's non-compliance with this technical filing deadline?
I don't think that's the owner's right under the statute. The statute's pretty clear, pretty technical, but it's plain and unambiguous with respect to the issues of this case.
Is the third-party purchaser in some way prejudiced, or does the third-party purchaser in some way rely upon the filing made with the department in a case such as this one?
Well, I believe, this is a valuable property. There's obviously competition here between the tenants and my client to acquire it. Obviously, it has value, potential, greater value down the road. So, that's the incentive here is to enforce the statute as it's written for the advantage of my client, obviously. But I think, the law is what it is, that, you have to follow the statute. Otherwise you don't have the right to complain. And so my client didn't violate the statute, didn't do anything wrong here. And so they should have the right to buy the property, whereas the other competing rights were not validly invoked.
Yeah, counsel, can I just see if you agree with this statement? Your client had a contract with the seller. Presumably that contract gave the seller the right to, back out if some TOPA right were adequately exercised. And I think your response to Judge Glickman is the seller didn't have a right to just back out on a whim. They couldn't do it for no reason. They could only do it if TOPA was validly invoked by the tenants. And when it's not validly invoked, the contract was good and should have been enforced. Is that something like your response? That's
exactly right, Your Honor. If the tenants had done everything correctly, my clients would not be able to buy the property.
So why didn't the tenants deliver by hand to the department in this case?
Well, they delivered by mail, and I've never heard that. I think it's pretty plain. There's a plain meaning of hand delivery is that, the person who's personally wrote the letter is delivering the letter, or has a messenger to deliver the letter to the recipient.
So you can use an agent to deliver your letter, like your neighbor, a courier service.
Yeah, courier service is fairly common. I think that's what hand delivery means. You take it there, and you might get a receipt that says I received this letter, on this date, but it's not through the U.S. mail. Even
if it's actually delivered as according to this, your item was delivered to an individual at the address, at 11:04 a.m. on August 31st, 2016, I guess.
And I understand Mr. Gill's argument that it shouldn't matter how it's delivered as long as it's delivered on time. But two judges, Judge Kravitz and Judge Sadler, both examined that and determined that that wasn't following the statute. I think the statute's pretty plain. I think if you try to stretch that statutory language a little bit here just to make it, more fair, that's a slippery slope, because then you have a precedent that says, well, we can make an exception here, then we're going to make
It's not an exception. We're interpreting the statutory language, and we would be doing it in a manner that seems to comport with the purpose of the statute, and that comports, in fact, with the provision of the statute that says that we should be interpreting ambiguities in a manner that strengthens the rights of the tenants.
Yeah, I understand, Your Honor, and I think the two modes of delivery specified in the statute, certified mail and by hand delivery, are very specific. I don't think they encompass every type of mail. And if it did, it would have said just simply by mail.
But the purpose of the certified mail requirement, as the council made clear in its report, is they wanted a mailbox rule, right? They wanted to make it possible for the tenants, if they used mail, to be able to have the full period to exercise their right. So that if you sent it on the very last day, and by sending it certified mail, you would have proof of when you sent it, right? Then you would achieve that objective. But if the tenants actually decide to exercise their right within the period and actually make delivery within that period to the owner, then it's hard to see how the purpose of the legislation isn't furthered by allowing that.
And I certainly understand that point. I would look to the Allman versus Snyder decision, that said it's not for the courts to make the statute more fair or any perceived inequities. The statute has to be strictly construed and strictly applied, and that the legislature had a certain intent. I think the Tippett decision shows that the legislature had a very specific intent by carefully using those exact words. It wasn't simply these TOPA statutes have been amended and updated many times, actually several times at least, and that provision, as recently as 2018, they amended the statute, and they left that specific language in there.
Mr. Crickman, could you I have a factual question that Mr. Gill sort of addressed, and I wonder if you can clarify it for me a little bit. What was the stipulation below about what did the stipulation say about what happened on August 31st? Was it that an individual at DCHRA received the notice? Was it that it was delivered, it was placed in a mailbox? What was the stipulation?
Everybody agrees that everybody stipulated that the notice was received on that certain date.
Okay.
Yes.
So let me see if I understand this, Mr. Crickman. If the representative of the tenants hires a courier service to deliver the statement of interest, and the courier service brings it to the department and handed it to the same individual who received it in this case, within the 14-day period, you would take that as satisfying the by hand requirement of the statute?
Well, I don't think that's for me to say. What the exact definition of by hand is, I guess that's an issue that the court could have been more specific in the lower court in its opinion, but certainly both lower court judges viewed it as insufficient, and I certainly would too. That it's.
See, I'm trying to figure out why it's insufficient. If I'm the tenant and I walk it over myself and hand it to the individual, you would say, well, that's by hand delivery. If I say, well, I can't make it that day, I'll have an agent deliver it for me, you would say, I think, well, that's hand delivery too.
Well, I guess,
And then if, and then, in other words, I don't see why it makes a difference whether the principal or an agent delivers the statement by hand.
well,
And so if there's a business out there that says, you know, we're really in this business of delivering things by hand, just for the price of a stamp, it's a great deal. So the tenant says, yeah, that is a good deal. I'll hand it to you. And you hand it, here's the stamp. You hand it, I paid for the stamp. Here's the statement of interest. And the post office, the postman, takes it on his truck and gets out the truck with the document and delivers it to the individual by hand. If that's done within the 14-day time period, I'm not sure why I understand why that should not be considered hand delivery within the meaning of the statute.
well, an agent acts on behalf of the principal. They have a principal-agency relationship, so they're really acting one of the same. If you hire someone to deliver something, I think that's different from the post office. I've never analyzed the issue of whether the post office is the agent of a person mailing a letter. I don't believe that would be correct. I think there's a difference, I guess, under agency law would draw the distinction between someone you hire to deliver something and the post office that delivers everybody's mail on behalf of the public.
Well, there is a reason based on, if we look at how the term is used elsewhere in the statute, in the provision of 423404.09, which deals with single family accommodations. That one does provide an F, subsection F, that a document delivered pursuant to this section shall be delivered. And then there are 4 different ways in which documents can be delivered. First class mail, a delivery service, certified mail, or hand. Suggesting, I don't know whether that's just meant to give more options to people in single family dwellings, or whether that suggests that hand and the other means of delivery are different. But I think Mr. Gill's basic point is that when you have actual delivery, that's what this statute really cares about, actual delivery within the statutory period.
I agree that the other statute, because it's specifically lists 4 different types of delivery and separates mail from hand, I think that even furthers the argument that the legislature intended for the statute that we're concerned with to be very specific and not include the other 2 types of delivery, but limited to only certified mail and by hand. So again, I understand the argument that it might be hyper-technical and that really
I'm sorry, I can't hear you.
Some sirens.
Okay, sounds good. Okay, so anyway, I was saying that the other statute I think only strengthens the argument that this statute was drafted for a specific purpose and should be, whether or not it's fair or not, like the Allman courts stated, it is what it is, and it's not for the court to stretch our statute to include the other 2 types of delivery that the other section of the statute specified.
Counsel, do you want to take a moment to try and defend the trial court's finding that the individual assertion of TOPA rights was invalid? I mean, if the collective assertion of TOPA rights was invalid, why on earth wouldn't the individual assertion of TOPA rights be fine?
Well, if it was invalidated at the time, and then Ms. Morstadt said, okay, well, I don't have joint rights, and I guess I better exercise my individual right. That would be one thing. But at the time, no one knew that the joint statement would be later invalidated. So she.
Well, they didn't know, but that's why you have a backup. I mean, the point is that you are saying that collective assertion of TOPA rights was invalid. So maybe nobody knew that, but you're telling me that that's the case. So if I take that to be true, what's wrong with the individual assertion of TOPA rights?
Again, that she didn't legally invoke her individual rights because she had already invoked her joint rights. And also under the Morrison statute, she was competing with her roommates, which was specifically barred by the Morrison decision.
Okay, let me give you a hypothetical, counsel. Let's say on the collective assertion of rights, a week before the time runs, me and my co-tenants send a notice by priority mail to the seller and DCHRA. The next day we say, oh, look at the statute. We messed up. We couldn't send it by priority mail. We need to do this by certified mail. Let's do it all again. We'll send it by certified mail. And they do that. Under your view, is that certified mail notification invalid because it competes with the priority mail notification, which itself is also invalid because it wasn't sent by certified mail?
I think if they had withdrawn their earlier joint statement of interest before asserting their individual interest, then they would have been okay. If they had made some kind of comment or notation that we realized we made a mistake, we're withdrawing that interest, here's our new interest, delivered within the proper time, that's fine. That's their only interest. But when both competing interests are out there, past the deadline, then we've got a problem. And I think that her roommates, at the trial, one of her roommates did complain, said she was pretty annoyed that Ms. Morstadt was trying to take the property out of in competition with the earlier joint statement of interest, and that's exactly what the Morrison court was trying to avoid by making a specific decision that would bar that type of activity.
Wasn't her, just a factual question, wasn't her notification, didn't it say something like this is meant in case the collective notification is invalid?
I think she testified later to that, but I don't think her individual statement had any type of language that.
Okay. You're on mute, Vanessa.
Sorry. Now, you say that it wasn't clear whether it was invalid, but you're also making the argument that the statute is very clear that by hand has a certain meaning, and this wasn't by hand, and it wasn't certified mail, so anybody looking at this would have known this was an invalid. You're not saying that if you submit something that's invalid, clearly invalid, it defeats the individual tenant's right, are you?
Well, I was saying that it may not have been clear to them at the time, but the individual, the joint statement was not invalidated until later. So she understood that she was submitting a competing statement when she also submitted her individual statement, and that's not permissible.
This is this notion of competition
That's
based on Morrison. This is that, but in Morrison was, first off, Morrison didn't deal with this situation at all. Morrison was dealing with a situation in which what Morrison said is you cannot have two people within the same unit, right?
Yes, and that happened here.
Providing conflicting or competing offers, right? That's not the situation here.
It actually is, Your Honor.
Well, not if one is a backup to the other. There's no competition then, right?
Well,
If Ms. Morstadt said only if the collective expression of interest doesn't work, right? Then as a backup, I will assert my individual rights.
well,
Why is that not allowable and not in conflict with Morrison?
Well, the statute doesn't provide for a backup. It's very specific that it's either collective. If there's no collective, then you get individual. And
I guess one concern would be, you could argue that when a person files a backup like this, there's a conflict of interest, as it were, between that person and the group with which that person was previously a part. The person now has, or could have, an interest in seeing the collective statement of interest disqualified, even though she was a part of that group. If she has a backup that would then come to the fore. And so you could argue, I guess, that that is what can bring this within the Morrison situation.
I agree, Your Honor, and I think that's why the statute has it as you do it jointly. If you don't do it jointly, then you have the right to do it individually. It doesn't say you can do it jointly, and then you can do it individually as well.
So the natural interpretation of or the natural consequence, I guess I should say, of that argument would be basically if the group purports to collectively file a statement of interest, that's it. That statement of interest either turns out to be valid and effective, or it doesn't. But that's the end of the inquiry from your point of view, because the time, because time is money, and people have to go on with their lives, and you can't have all these backups and conflicts between tenants that can delay things. That strikes me as basically a rationale for your position.
Exactly, Your Honor. And like you said, once the joint statement of interest is submitted, that needs to be followed up and determined, because like you said, if someone else had another individual interest, they might have an incentive to do something to protect that interest and do something to denigrate the joint interest in their own favor.
Now, cutting against that, I suppose, would be the counter argument that nothing in the statute precludes backups, and the statutory language doesn't really encourage this kind of an argument, because there's a specific provision that says that we have to interpret ambiguities in the light most favorable to strengthening the tenant's rights. Do you agree that undercuts the rationale you and I have just been talking about?
Well, I agree that if there was an ambiguity, then you would interpret it. You have to interpret it in favor of tenants' rights. Here, I don't think there's an ambiguity because the statute contains the word "if," and that's a conditional word. That means, if this doesn't happen, then that can happen. And I think Morrison supports that interpretation by saying you can't have those two interests. You either have one or the other. They can't compete with each other.
So long as a statement of interest is submitted by tenants jointly, it doesn't really matter whether it satisfies the statute. So for example, if a statement of interest is submitted that purports to be by all of the tenants, but in fact is missing a couple of them, or is filed late, or as in this case, according to your argument, isn't sent in the proper manner or delivered in the proper manner. None of this matters. So long as some piece of paper or some expression of interest is attempted, that's all it takes.
Well, it has to be properly, as long as it's properly delivered with all the tenants as a joint expression of interest under the statute, then it's valid.
Yeah, but this one wasn't. That's the whole
Right.
point, that this one wasn't.
Right. So that's why at the time they thought it was. The court obviously later invalidated it. But at the time, certainly Ms. Morstadt thought it was valid. She even, as we all know, she said it was her interest was a backup. But by doing so, she was basically undercutting her roommates and all the other tenants by creating a competing interest that's not supposed to be there.
All right, so you're, and I know we're taking you a little over time, and I apologize. You keep saying, somebody might have thought it was valid. So let's just take that out of the equation. Let's say that a group of tenants, they hold a seance, and they summon the spirits of DCHRA and the seller, and they say, we confer upon you, we want you to know we want to exercise our TOPA rights. And then then one of those tenants says, you know, I'm not so sure a seance was the best way to go. I'm going to go ahead and send in my notice by certified mail, just in case. Is that tenant's notice still not valid in your view? Preempted by the seance?
I think if she had, I think she would have needed to have raised that at the time, because nobody else knew why she was doing her. I mean, you know, there's no indication at the time that she was withdrawing her earlier joint assertion because she thought it wasn't delivered properly. So now I'm going to assert my individual right. She was clearly intending to assert two different rights. So that's my argument, that it's that's the reason why it was why she couldn't do that, and that's why the law prohibits that.
Mr. Crickman, thank you. We've given you a little extra time because Mr. Gill got a little extra time initially. So we've heard your argument, and let's hear now in rebuttal from Mr. Gill.
You're on mute, Mr. Gill.
Thank you. 2 points I'd like to make that are really principal points. One is, with due respect to Mr. Crickman, who's an experienced and able advocate, I think he has misinterpreted the Morrison case. The Morrison versus Branch Banking case does not stand for the proposition that an individual expression of interest by a tenant is impermissible if there's been a collective expression of interest. Morrison involved competing individual expressions of interest. So it was a complicated set of facts, but it's very clear from the opinion that the court was grappling with individual expressions of interest by tenants that had been assigned to two different parties who then filed lawsuits based on both. So there were competing claims from the same rental unit. That was the issue that was presented in Morrison, which is obviously not the issue that's presented here. There's nothing in the Morrison opinion, and there's nothing in the TOPA statute that says if a collective expression of interest is somehow attempted to be effectual and is invalid, then there's a forfeiture of the individual tenant rights. And I think interpreting the statute in that way would be a fundamental injustice and would be in derogation of the command, that it's to be interpreted in a way that strengthens tenants' rights. I'm not aware of any authority that supports the position that Mr. Crickman has taken with respect to the individual expression of interest by Ms. Morstadt, which is very clear in the record was timely and correct in all manners. The other issue I'd like to address for just a minute is the assignment agreement, because Mr. Crickman had also claimed that the assignment agreement that had been signed by the tenant was somehow invalid. And my position on that is very clear. Either the plain language of the assignment agreement, which says that it is an assignment of collective and individual rights, was plain and effective on its face and unambiguous and enforceable as written, or alternatively, it was ambiguous. And in that case, the parole evidence that came in at trial from the tenants, which was completely consistent, uncontradicted by any testimony or other evidence from Mr. Crickman, said that the tenants absolutely intended to assign and convey all of their TOPA rights that they had, individual and collective. They intended to keep nothing from the assignment. So the notion to me that there's anything ineffective in the assignment is absolutely improper, which reminds me to bring up the issue of the citation by Mr. Crickman to the Allman versus Snyder case, where Mr. Crickman was reminding us that the court said, look, we've got to interpret the statute as written. But let's keep in mind what was going on in Allman versus Snyder. Allman versus Snyder was an attack on an assignment of TOPA rights by tenants, and the court had to remind the parties in Allman versus Snyder that TOPA absolutely permits the assignment of TOPA rights. They're freely permitted in any way the tenants wish, and they're to be recognized and enforceable. And it was the effort to interfere with the assignment in Allman versus Snyder that the court reversed. And for those reasons and reasons I've stated here, the attacks that Mr. Crickman has made on the assignment agreement here, I think, are invalid. The last thing I would like to say is, with respect to the position of the owners of the property who submitted a paper that took no position on the merits of the underlying dispute, but did ask that there be some sort of remand. I would like to have a final judgment with respect to the TOPA issues, but I do not object and think that it may be appropriate for remand on other incidental issues to the trial court.
And these are issues that the trial court never got to, or that they would have to be decided differently because of a different outcome?
I think that would have to be decided differently because of a different outcome. There's nothing that I'm aware of that the trial court did not address. But once we get a final judgment on the issue of the TOPA rights, then there may be other incidental issues that, including an order requiring conveyance, things like that would need to be done in the trial court.
Thank you.
Counsel, thank you both. We have your arguments, and the case is now submitted.
Thank you.
We will call the next case. Ricardo, may we call the next case now?
Bring in counsel. Thank you, Judge.
Thank you. We're calling the next case. This is the case of Gary Simon versus Summer Smith. Also referred to in some of the pleadings as Summer Smith Simon. Counsel?
Good morning, Howard Sofer on behalf of the appellant, Gary Simon.
You may proceed.
Thank you. Will I be able to reserve 5 minutes at the end of my time?
Yes, you will.
Thank you.
And you just have.
As a preliminary issue, the appellee's brief contains numerous citations to things that are not part of the record. Cases, things that may have occurred after our trial, and a host of other things that are not in the trial record. I'm not going to address those items because I don't believe they're properly before the court and don't want to spend my time on them, but they should not be part of the record and shouldn't be considered. So I'm going to leave it at
Well,
that.
I want to ask you about that then, because one of the things I think you're referring to is that records of the Superior Court, apparently, we are told, contain filings by your client, Gary Simon, in which he identified himself as the trustee of the Gary S. Simon Revocable Trust. Why is it we shouldn't take judicial notice of those filings in the records of the court?
Well, if they occurred after this trial, I don't know what the explanation, I never pursued it. There could be an explanation. Even if they occurred before, judicial notice usually occurs at the trial level, at which time they could be presented and Mr. Simon would have an opportunity to put testimony on to respond to it, whether it was filed in error, whether it was signed in error, or whatever it may have been. But right now we're left with something that he can't respond to, but it's treated as a fact that was presented at trial. Anytime an alleged fact is presented at trial, someone has the opportunity to offer corresponding evidence. That did not occur with any of those items.
You can respond to it now. I mean, so the representation that they're making is the day after you said you weren't in control of the trust. In a different court proceeding, there was a representation that your client was in total control of the trust. So that's the thing we would take judicial notice of. If you want to respond to it, here you go.
Well, it's not part of the record. I'm not sure how the court can consider on this appeal something that's not part of the record. I don't represent Mr. Simon in that action, so I don't know what facts I could respond to. And even if I allege them now, whatever response I would provide, frankly, isn't a fact in the record either. So I'm not sure where that gets us. Well, no matter what I would tell the court now, if I had something to say factually in response to that, it's not a fact in the record. It could be made up. I don't know what the basis is. To be judicially noticed, respectfully, Your Honor, it has to be presented at the trial level where it could be addressed and discussed at the time.
Counsel, it's just not true, counsel. We have cases where we've taken judicial notice of when the sun sets on a particular day, of what a newspaper said on a particular day, and we do it at the appellate level. And if somebody asks us to take judicial notice of it, we can look at it. And if you want to say, oh, that's not when the sun actually set that day, that's not what that newspaper said, that's not when that bus actually ran, you can do it.
I don't have a specific, I'm sorry, Judge, I didn't mean to cut you off.
I just mean, like, be my guest. Don't say that you're constrained and you can't say anything to the contrary. Did your client represent in a different Superior Court proceeding that he was in control of the trust the day after he told the trial court, in this case, the opposite?
I don't know the answer.
Okay.
Going back, if I can, unless there's another question, I'm going to go ahead. I think the problem that you have in this case is you have a joinder situation with two different trusts. And the law is pretty clear under the statute, that is Rule 19, that a party on its own motion or the court on its own initiative, just as happened in the Graves case, which we cited, must order the joiner of indispensable parties. And that is the standard. It's not simply that a party didn't raise it at trial, although we did raise it at trial. The court is very clear in Graves that the court should do it on its own. And in fact, at Graves, it didn't come up until it came to this court. And the court's very clear if you read the footnotes. In footnote 13 in Graves, where neither party seeks to join a necessary party, the district court has an independent responsibility to assure the just and final resolution of civil disputes, and the Court of Appeals should take steps on its own initiative to fulfill Rule 19 policies. In this case, I raised the issue with Judge O'Keefe at the trial, and he's required to perform an analysis, and that analysis is set forth in the Raskauskas case, Raskauskas versus Temple Realty, which is cited in our brief. At no time did Judge O'Keefe perform that analysis. At no time, if you read the entire 39-page opinion, does the word join or joinder appear. If he had discretion to consider it, he never exercised that discretion. When a judge is afforded discretion, he or she must exercise it. They can exercise it either way within the limits of the abuse of discretion standard, but they can't elect not to do so. And he
Is
never-
Graves
so in this case-
authority for the proposition that when the trial judge does not do the exercise of discretion, as you put it, do the balancing, do the consideration, that it can be done on appeal by the appellate court?
Well, in Graves, the court did that. There was evidence presented that Mrs. Graves' father held title to the home. Neither party raised it. And on appeal, this court, the Court of Appeals, said that it was error, and that the judge should have joined Mr. Graves to protect Mr. Graves, the father. I'm sorry, Mrs. Graves' father, probably a different last name, to protect her father. And the court had the obligation to do that to protect his rights. That was
So
done
the
by
appellate
of
court,
Appeals.
the appellate court in essence determined that Mr. Graves was an indispensable party.
They did, correct.
Okay.
And
So
in
we
this
could
case,
do that here. We could make that determination here.
if there's evidence, if the court believes there's sufficient evidence on the record, this court can do it here. Judge O'Keefe did not do it.
Could we
So
do
as
the
it
opposite? Could we also determine that the trusts are not an indispensable party if there's sufficient basis in the record?
If there's evidence in the record, this court can do, well, I think it still has to be remanded to Judge O'Keefe to make that determination. I don't know that this court can exercise his discretion for him. If he didn't.
I mean, why shouldn't, for example, why shouldn't we say that the irrevocable trust really has no interest in any of this at all? And the revocable trust is adequately, its interests are adequately protected by the fact that Mr. Simon himself, the sole beneficiary and grantor, and perhaps the trustee, is before the court.
First
I
of all,
mean-
go ahead, sir.
Well, go ahead, I'm sorry.
The evidence in the record was not that Mr. Simon was the sole beneficiary of the revocable trust. He testified that the party's two sons are also beneficiaries of that trust, Derek and Darren. So a lot of times there's a trust where you have a present beneficiary and contingent or alternate beneficiaries or multiple beneficiaries, and their interests are not often aligned. So a third-party trustee in this case may say, I don't care what Mr. Simon's alleging. I have an obligation to protect the two children beneficiaries in this case, and I have a fiduciary obligation to defend against that. The trustee may say, I didn't hire Howard Sofer. I wouldn't have chose him as the lawyer to represent the trust. I would have hired so-and-so to do it. That's who represents the trust, or that's who I have a relationship with. They're not bound by, well, I hope Mr. Simon's protecting it. You've got two other beneficiaries and you've got the choice of counsel. They have an absolute right. I think where the problem.
How do we know that the sons are beneficiaries of the trust?
Mr. Simon testified to it. There was no evidence to the contrary. There
The
was no
trust document
suggestion by-
itself is not in evidence, is that right?
I don't believe it was, but I think, again, the big problem that lies in
Are
this.
the, are the sons contingent beneficiaries, or are they beneficiaries at the same level as Mr. Simon?
He testified that they were beneficiaries. I couldn't find anything more distinct in the record. But I don't think it makes a difference, because if they're present beneficiaries, they may still have a different interest than him. And if they're contingent beneficiaries, they would have a different interest, such that they may not want trust trust principal expended now and have it extend in 2030 or at a later time. So I don't think it makes a difference whether they have the right to an interest now or you have a contingent beneficiary interest. As we often see in trust litigation.
Well, I wonder if that's true. I just wonder whether a contingent beneficiary would really have standing, and if not, why the trustee, whose primary duty would be to the, well, I'm just not sure.
Well, contingent beneficiary certainly has it, because if you look at a trust, you look at it as a timeline. You have a lifetime beneficiary, and then you have alternate beneficiaries, usually after the primary dies. So it's still the same timeline of the trust. The contingent beneficiaries aren't entitled to any less protection or fiduciary obligation. The trustee can't just simply, I'm going to spend all the principal now for this beneficiary without considering what's available for the secondary beneficiaries.
Is that true? Doesn't that depend on the terms of the trust, which we don't have? And maybe that's the answer, that
That would
without
be
the
the answer.
trust, that's something that needs to be looked at
And that is,
as a factual matter. But the trust was not submitted to the trial court either, right? I mean, we don't have it because the trial court didn't have it.
correct. But I think here's a big distinction in this case that doesn't appear in any of the other cases regarding joinder. In this case, there's no pleading where these claims are requested. So there's no opportunity to say to the trustee to provide them on notice, here's a copy of a pleading filed. Here, we're on notice of this being filed. None of this existed. So we have a situation where as the trial evolves, Mrs. Smith pursues some additional claims. The judge makes some comments. The first we hear about unconscionability is very late in the game. She makes inconsistent statements about whether she signed it or not, but at no point is any of this pled. The court, to determine the validity of the trust, there either has to be an enforcement action, because unconscionability is not an offensive term. There was no enforcement action. Neither the trust nor Mr. Simon nor anybody thought to enforce these contracts, or there has to be a declaratory judgment action where a court can define parties' rights under an agreement. And for a declaratory judgment action, the court has to consider it as set forth in 28 U.S.C. 2201 upon the filing of an appropriate pleading. Nothing was ever filed. There was nothing to send the trust and say, these issues are being tried today. Everything sort of just came up willy-nilly. And I know Judge O'Keefe had a desire.
Let's go back a second though, if we could, because I hear your argument that some things weren't necessarily planned. This was a divorce action. And if it was so important, I mean, it became clear soon enough to all parties in the litigation that the validity of these property and lease agreements that Ms. Smith was a party to was going to be examined by the court. And naturally it would be examined by the court in a divorce action, when the court is separating the property of the parties. So Mr. Simon had the opportunity, it seems to me, to contact the trusts if they really are independent of him, and bring in the trustees himself if he thought they were important. And he's confronting a pro se litigant while he has sophisticated counsel. He unquestionably can bring in the trusts themselves or give them notice, of which he is the beneficiary. If there exists any concern that the trust's interests might be impaired, and yet he doesn't do that. And he plays, in effect, his strategy smacks, tell me if I'm wrong, of gamesmanship. He basically raises the issue, but doesn't lift the finger to get the trusts in himself or give them notice. They could have intervened if they wanted to. And when I see that, I think to myself, well, maybe that's an indication that in truth, either the trusts don't have a serious interest at stake here that would be impeded by the actions, or Mr. Simon, who's making this motion and who has the burden of proof, is nonetheless satisfied that he can protect the interests of the trusts, in which he obviously has an interest himself. So what's wrong with that thinking?
I don't believe it's gamesmanship, Your Honor. Unlike some of these other cases, I did not raise the issue for the first time on appeal. Judge O'Keefe and I had a somewhat robust discussion on it on the last day of trial when the issue came up, and I raised the joinder, and he and I went back and forth, and those are quoted in our brief and are certainly quoted in the transcript. At that point,
I think that on the last day of trial is the part that Judge Glickman is suggesting might be gamesmanship.
Well, but remember, these issues didn't really arise until we had the trial was staggered over time. The issue with the validity of the trust didn't come up until the last partial hearing on September 13th. The record doesn't reflect it. That was a telephone hearing.
Again, I think part of Judge Glicksman's question is obviously this was going to be scrutinized. Counsel would have known that.
Respectfully, I don't think it was obviously going to be scrutinized until the earliest indication was September 13th of that next to last day. I could have the date wrong, but whatever the next to last hearing.
Can I ask one more question? You know, kind of going to his point about you being an adequate representative of the trust itself. Here you are in the appellate court making an argument that strikes it basically on behalf of the trust. You know, and this kind of goes to footnote 3 in your reply brief, and something the appellees say is, you know, so if the court made a mistake, maybe the trust has some right in a collateral action. Maybe if she tries to sell the condo, the trust can try to intervene. But here, it's really you arguing for the trust that they are an indispensable third party. And we haven't heard that from the trust themselves. Why is it that you get to represent the trust interest now, rather than the trust being able to assert their own interest in any sort of collateral action that might come about?
I don't think they're required to do it. The appeal, just as Mrs. Graves's father didn't intervene in the appellate to have to make.
Yeah, I agree. Graves is a problem for the way I'm thinking of it. Can you talk to me about it without saying Graves, though?
I think that, frankly, I think that's an accurate aspect of the law. And because this court endorsed that in Graves, I'm endorsing it here. If this order is remanded, we would ask for that the order be clarified, and I'm running out of time, that the order by Judge O'Keefe is not binding on the trust and is solely binding on Gary Simon individually. I see my clock.
Well, I want to ask you a couple more questions on this. What interests would the trust assert if they were part of the litigation that Gary Simon could not make or did not make, or were not in his interest to make?
If it were me, if I represented the trust, thinking about it now, having this discussion, if the court found that they were unconscionable, even though that wasn't pled, I would probably put on evidence as to the 9 to 8 years of transactions between Mrs. Smith and the trust and her getting payment and the parties abiding by the terms of it for all that time. Evidence was presented as to the fair market value of the property, the tax assessment value. The court was concerned about that. If I was the trust, I might get an appraisal and put in the fair market value of the condominium.
Oh, I understand that any
all of
party,
those.
but why is it the case that those are things Mr. Simon couldn't do
But
and didn't have an interest in doing?
He didn't do it at the time. He didn't represent the trust, and the issue of unconscionability didn't come up until the last day. The issue all along, Ms. Smith first claimed she signed it, then she claimed she didn't, and she changed 3 times. I forget what she started with. Didn't sign it, signed it, didn't sign it. So we thought that might have been an issue. The court never made a finding whether she signed it or not, and then got into unconscionability and all these terms. So it was a moving target that was constantly being swung at. And I just don't see how, without proper pleadings, discovery could have been taken when Ms. Smith was deposed in July of 2018.
You know, I think maybe I didn't ask my question to you in a way that made it clear. I'm wondering how the trust's interests are actually impeded or impaired as a result of this litigation. This is really, in a way, a follow-up on the question that Judge Deal asked you. What's the consequence for the trusts of this outcome in this case? They're not parties. The order, they weren't before the court, as you say. So what is the respect in which their interests are impeded?
I think the concern could be as some sort of res judicata effect. If the trust sought to enforce its terms against Ms. Smith or her revocable trust, she'd come in and say these issues had been adjudicated. The trust.
Well, if res judicata applies, then it's because indeed Mr. Gary Simon was the adequate representative of their, or protector of their interests. If he wasn't, then res judicata, I think, would not apply to them.
Correct, but the issue would have to be determined. So we have an entire additional trial with Ms. Smith and or her revocable trust.
That's only true if the trusts actually do have an interest and do at some point seek to assert it. The very fact that they didn't try to intervene in this litigation is itself some indication that they don't really have any interest in this and that they're really not independent from Mr. Simon, and the fact that he didn't seek to bring them in could be taken to suggest that, although it could also be taken to suggest some other less appropriate things. But I'm having trouble understanding how there's a real practical impairment of the interests of the trusts, and how Mr. Simon was not a perfectly adequate representative of whatever interests the trust did have.
Again, I think it's significant that there were no pleadings setting forth claims of unconscionability or fraud. Fraud has to be pled with particularity. Numerous cases like that, I think we all know that. None of these pleadings existed. Nothing was laying out the claims and putting on notice.
Well, as for fraud, I don't think the judge made any findings of fraud. He said a number of things smelled fraudulent, but he didn't rely on those findings as I read his rulings. Now, unconscionability, he did make a determination of. Substantively, would you agree that the agreements in this case, well, what do you think the legitimate, could you, maybe we should segue into this. Could you explain the legitimate purpose of these agreements? Of an agreement in which Ms. Simon gives all her present and future personal property to the down to the clothes off her back, to the revocable trust of Mr. Simon, of which he is the beneficiary, or a beneficiary, and an agreement in which she gives essentially all, for 20 years at least, of her economic interest, all the bundle of rights that as owner she would otherwise have of this condominium apartment to Mr. Simon or his trust, and getting nothing in return. It's really extraordinary. I mean, a married couple in which the wife is induced to sign an agreement giving everything she owns in practical effect or in legal effect to her husband for virtually, is astounding to me. I might as well say that. And I'm interested to know what the legitimate purpose of this agreement was.
Let me start with your second point first about the lease agreement, and I'll work backward if that's okay, Judge. You
Sure.
asked about giving the lease agreement for the term of it. Ms. Smith received payments every month from that.
Well, but if you look at, let me stop you, because what she received, as I understand it, was $750 a month, which first of all is very much below the market rent. But second, it doesn't go into her pocket because it just goes to pay the mortgage. And under the lease agreement and you have to read these two agreements together. But under these two agreements, when read together, all the overage is retained, the word is used, by Mr. Simon. And the agreements basically say he'll use some of it to pay for the various expenses associated with the apartment. But there's no protection for whatsoever for her as to, well, what about the overage that exceeds the expenses? The agreement is completely silent for that. And then when Mr. Simon said, well, show us what you've actually spent for the expenses, he's unable to show that he really did use the excess rentals for that purpose. Instead, he's able to show that he used it for purposes that the court found were unrelated to the agreement. And he's given the opportunity to apply everything he spends from the rentals on her apartment as the price to the price that he will have to pay itself a below market price, a fixed price for 20 years on a rental apartment. I found this agreement astounding, frankly. And this is just one facet of it. Everything else, she gave all her property to him, in effect. Unbelievable. I've never seen an agreement like that. Have you? Have you as a lawyer or ever seen or heard of or been involved in creating such an agreement between a married couple?
Did you may address that one first?
Sure.
I can't recall in 23 years whether I have or I haven't, where I would see things like that in context. People put things in trust for creditor protection and held assets that way for creditor protection. I'm not sure if that might have been the motivation.
Does she have creditors that she's trying to protect her assets from it? Because what this does is exposes her assets, not protect them.
Well, he certainly had credit.
He's the one who has creditors. So her giving him all her assets is an example, I would think, of, I mean, normally,
Well,
you
he
know,
didn't
I
give
would
her-
think it's an example of exposing her assets to creditors, not protecting them.
Well, we're talking about tangible personal property, first of all, non-titled assets. So furnishings and things in someone's home. She did not give all of her assets. As the court may recall, at the time of trial, she had a brokerage or bank account with a value of about 120, I could be off a little bit, about 120 odd $1,000 or whatever it was. That certainly was not part of this. That was her separate property and was not contributed to the account. So to the extent, certainly not all of her assets were contributed, and her most valuable net asset, because the condo had a mortgage, her brokerage account was not contributed. That's been her separate property, free to use as she's wished all along, unencumbered, no claims to the contrary. With respect to some of the other questions you asked me about the residential lease agreement, for all of these years, Ms. Simon testified. Mr. Simon would handle the tenants, would take the payments, would do all these things, would make the repairs, did everything. She didn't have to put a dollar into it other than the initial purchase. And these were the arrangements they followed from 2010 till about 2018. So this is how they proceeded. She had never complained about it before. She didn't complain about it in her complaint. She complained about it sometime mid-trial. That is the first any complaint that she had about these things. She had no out-of-pocket. When things needed to be repaired, they were repaired. When Your Honor commented, well, he could have presented these claims, this wasn't an enforcement action. Mr. Simon did not say, I want to enforce my lien in this proceeding, and laid out his claims. It was never pled. It wasn't part of this proceeding. The judge asked him questions about it, but if and when the time comes that he wants to pursue his enforcement claims, he'll have to do it. A trial judge will have to make a determination whether he's met his burden of proof in that form where those claims were pled. He never pled them. I don't see how he could be forced to plead affirmative claims and pursue affirmative claims that he didn't seek to pursue.
Well, I think part of the reason is that she's walked away from any claim for anything other than her property. I mean, she's just given up a lot.
I don't know that
Thanks.
she's given up.
Right.
I don't know that I agree that she's given up.
I mean, for example, this says she's given, well, maybe she hasn't given it up, but she certainly, this says, and let me see if I can get the language, that I, Summer Smith Simon, hereby transfer all my interest in any and all tangible personal property that I may own, including but not limited to my household furniture, furnishings, collectibles, clothing, linen, china, silverware, books, jewelry, and art, except such property requiring separate documents of title. Okay, there's something she couldn't do. I also declare this, she says, I go on to say, I declare that all similar tangible personal property which I acquire after signing this document, so anything she acquires in the future, will also be an asset of the Geary S. Simon Irrevocable Trust. It's an astounding agreement to me, to be honest. I've never seen something like that before. And then, of course, it has separate provisions to deal with making sure that all the benefit of the condominium real property, the only real property she owns, she's unwilling to give up title to that, but she's giving up a tremendous. She's giving up basically. If you think of ownership as a bundle of rights, she's keeping the title, but she's given up all that bundle of sticks, those rights to him. It's to me, there is something very substantively disturbing about this contract.
Well, I didn't answer before, but
And it's not exactly people at arm's length. This is husband and wife.
I understand, but they followed it for 7 to 8 to 9 years. This contract was followed, and there was no issue there. I think there's also a statute of limitations issue there as well. Of course, Mr. Simon couldn't plead statute of limitations as affirmative defense because there was no pleading stating the claim. There has to be a claim in order to assert an affirmative defense. With respect to the real property agreement,
She's not seeking damages from. She's not seeking damages from the contract that statute of limitations might have run on. This is simply a divorce action in which the parties' property interests are being separated. And it's very hard to understand how it would make any conceivable sense for these contracts to continue in effect after these two parties are disunited.
These are property interests, as we started this discussion, of trust. And I think that's what needs to be considered.
Well, right, I understand what you're talking
We
about.
had that discussion. With respect to the purchase price for the property, you said it's less than fair market value. At the time the agreement was signed, the purchase option price was $290,000. Ms. Smith testified she paid $210,000 for the property just a few years prior. So that the agreement that had a list purchase price of $290 allowed for future increase of property and increase in value. In fact, at the time of trial, it was less than 1% difference in the tax assessed value.
Yeah, maybe I should have said that. It's just very odd that you would fix a price for real estate that could remain a fixed price for 20 years into the future. Very few people, I think, would engage in that kind of transaction.
It could have gone down, but the reality is it was much greater than the purchase price. And true to form, at the time of trial, it was spot on, give or take $1,400, but it reflected the fair market value of the property at that time. I think the court clearly had
So defend for me the conscionability of this of these agreements.
Well, we talked about the residential lease agreement. It's certainly not unconscionable. For all of the years, Mrs. Simon received a portion of the rent. Mr. Simon paid all expenses of the property. Mrs. Simon didn't pay any expense. She didn't have to deal with tenants. She didn't have to deal with cleaning. She didn't have to deal with any cost of the property from 2010 through the time of trial. None of that. It was paid for by Mr. Simon or the trust. And throughout that entire time, that's what was covered. And he has a right to make a claim at a later date. He has to prove his claim, he or the trust, and what they paid. So if a court finds they have to submit receipts, they'll have to submit receipts. If the court finds testimony is sufficient, so be it. He still has to prove his lien. Maybe the court finds it's zero. Maybe the court finds it's $180,000.
Well, do you think
he has the right to make that claim?
Leaving aside what effect this judgment has on the trusts, do you think that this judgment, the court did not have, I'll use the word jurisdiction, to render this judgment against Gary Simon himself and say, look, I'm divorcing you two. Your rights under these agreements are over?
My concern is some of the case law that we cited in our brief says where the issue is, the court is being asked to determine the validity of agreement. It's one of the cases we cite. I think it was the Devers case or Devers case, however you pronounce it. I can look it up. It's in my memo. The court said where rescission is what is sought, there's a general rule that when rights sued upon arise from a contract, all parties must be joined. Word versus Devers. Rescission of contract or declaration of its invalidity as to some parties but not as to others is generally not permitted. So in general, all the parties need to be joined in that action. And again, what we believe should occur is Mrs. Smith is free to pursue these claims against the trust, Mr. Simon or whomever. They should be pled, they should be proper allowance for discovery, and she can have her day in court. Obviously, we don't think the divorce action should be dismissed, the custody, the child support, the divorce, and all of that. Those were properly before the court in this form and were put on notice from the outset. But I do think everyone is entitled to their day in court. Mrs. Smith is no less entitled to her day in court. But simply because she's pro se, she should still have the obligations to plead properly, allow parties to take discovery property, and allow parties to be represented properly. Doesn't change any of it, respectfully.
But all of this is contingent, of course, on the first question, which was, are the trusts in fact indispensable parties?
Yes, and I didn't get a chance to answer that question. But when you go through the analysis, if you look at Rule PRB 19, and they re-amended the rule, they laid out the factors. And the first thing that a court considers, looking at the extent to which a judgment rendered in the party's absence might prejudice that party or the existing parties. It impacts the trust beneficiaries. To the extent the beneficiaries are not Gary Simon, there's no question it impacts them. They had no knowledge of this proceeding. They weren't involved if they're minors, and there was no trustee or anyone else on their behalf to protect them. Factor 2, the extent to which any prejudice could be lessened or avoided by protective provisions in the judgment, shaping the relief or other measures. If this is remanded to the trial court, a new order should state expressly that this is not binding on any of those trusts. If anything.
Who bears the burden on this question of indispensable parties?
Well, it's interesting. It says on the party's own motion or the court on its own terms, and one of the cases talked about the court having a sua sponte obligation to do it. I think that was American University, not Raskauskas. I don't necessarily think that the burden falls on any party, because remember, I know Judge, I want to hear Graves again, but in Graves, neither party met any burden, and the Court of Appeals found that the trial judge had that burden. And when you look at the American University case, the language in that case, and it's cited in our brief, says the trial court had a duty sua sponte to and to cause AUD to be joined in the suit. The burden in that case was on the trial judge, whomever that may have been. And again, they cite Supreme.
In that case, the action was then brought by the indispensable third party, AUD. And here, and that's what the notes to the federal rule 19 say is, you know, if a court's wrong about an indispensable third party, it doesn't lose. This is notes to the 1966 amendment to Rule 19 in the federal rules. Even if the court is wrong about whether or not a party is indispensable, it doesn't deprive it of authority to issue a judgment. It's just that it won't be enforceable against the indispensable third party. So, like, nothing to do here. That would be subject to some collateral action.
Part of the problem with that is when you read Judge O'Keefe's opinion from his order, he indicates that this is binding on 9 lenders and other third parties that have.
Okay, so it's advisory.
I think if this was remanded back to the trial court with instructions to enter an order that the terms of the judgment of absolute divorce of November 21st, 2018 do not apply to any of the trust or any third party other than 2 of them, that might be a sufficient remedy.
By the way, I want to clarify something. I wasn't sure I understood.
Yes, sir.
You were mentioning that the sons are beneficiaries, possibly contingent beneficiaries, but put that aside. Which trust or are they beneficiaries?
I know Mr. Simon testified to that. I read it this morning with respect to the revocable.
So if it's revocable, okay.
I'm sorry.
No, go ahead. Okay.
So I read that testimony this morning. So that's what he testified to. I don't believe there was testimony as to the irrevocable trust, but it would make sense that there is some contingent beneficiary to an irrevocable trust, because if Mr. Simon was the only beneficiary upon his death, it's irrevocable. Assets would belong to nobody for nobody. In no situation, the trustee would have no obligation to anybody. So
with regard to the irrevocable trust, by the way,
But-
with regard to the irrevocable trust, one of the agreements, I forget which one it is, identifies Summer Smith Simon herself as the trustee of the irrevocable trust. And that's clearly not a typo. In context, it's clear that that's meant. Does that mean that the irrevocable trust was on notice of this hearing and of these issues?
No.
And in fact, you could say it was represented, except she wasn't actually appearing there as a trust representative.
2 things. If that's true, if she's the trustee of the trust and she seeks to have it invalidated, she has a conflict of interest. She certainly can't be on both sides of an equation. But I don't even think that's true. On the first side, the current trustees are Mr. Greenhouse and Mark Simon. Those are the current trustees. Those are the parties that are to be parties to any action regarding the irrevocable trust. And we cited language in our brief that the proper parties to litigation to receive notice where a trust is involved are the current trustees. You may have cases where you have a contingent trustee that he or she doesn't even know that they're named as an alternate PR in a will or as a trustee because it never came to them. And they'll be notified when the time comes. Respectfully, the current trustees are the ones that are entitled to notice, not some second or third contingency who may or may not know, and frankly shouldn't be invalidating an agreement in which she is named as a trustee. She couldn't be on both sides.
Okay. Thank you. Well,
I tried to answer most of your, I'm sorry, Judge Glickman, go ahead.
no,
sir.
I was going to say we've taken you over time, and I appreciate your patience with us, and we'll give you a few minutes in rebuttal, and let us hear from Mr. Werlinger.
Thank you, Your Honor, and may it please the court. Following a 4-day bench trial, the Superior Court invalidated 2 unconscionable postnuptial agreements that gave Mr. Simon complete control over a condo belonging to Ms. Smith. Mr. Simon asked this court to overturn the judgment due to a series of alleged procedural errors. Now, subject to the court's questions, I'd like to focus on joinder because I think that's the main issue in this case. When it comes to joinder, Mr. Simon has failed to answer the key question at the heart of that issue, and it's the same one that Judge Glickman that you just posed. What would be different in this case if we were to have joined the alleged absent trustees? The answer is nothing. Mr. Simon does not give a compelling explanation of how any of these alleged absent trustees had an interest in the postnuptial agreements. And even if they did, Mr. Simon has not demonstrated that any of the trustees was prejudiced by their absence, given Mr. Simon's aligned interest and vigorous defense of the postnuptial agreements. He has fallen far short of the high bar that is abuse of discretion review, and the judgment should be affirmed as a result.
Counsel, I guess my hang up with that is we don't have a finding from the trial court or really any analysis at all saying that he was adequately representing the trust interest. It's a little bit peculiar, at least for us to make that finding in the first place. This is something that was raised before the trial court. And so I suppose my question is, why isn't that a proper issue for remand as to whether or not the trust interests were adequately represented by Mr. Simon himself?
Well, Your Honor, if I may, I'd like to break that down into kind of component parts. I do think we have a decision on this issue. During the October hearing, when Mr. Simon first brought up this issue, the court had an extensive colloquy with my colleague on the other side, where they went through the analysis that was required by Raskauskas. That colloquy appears at appendix pages 396 through 437, and we summarize that colloquy at pages 16 and 19 through 19 of our opposition brief. At the end of that colloquy, the court said, if I determine that there is an indispensable party, we will give that party notice and an opportunity to be heard. The court proceeded to judgment with only Mr. Simon at the table, and the logical conclusion from that is that he denied the motion. What my colleague is really concerned about is that we don't have a written decision on this issue, but a written decision is not required under the rules.
It's not that it's not a written decision, counsel. It's that saying, you know, if I decide this one way, I'll do this, and then nothing is spoken about it again. It is tough to read an implicit finding in that. I mean, I take your point that, I mean, you're saying that that was announcing sort of a one-way ratchet. If I don't say anything at all, then I'm siding with this not being an indispensable third party without giving any reasons. And that's peculiar too.
Well, I think, so Your Honor, I want to focus in on that. It's a conditional statement. I think as you've identified, it's a conditional statement saying that if I am convinced that there is an indispensable third party, we will join them up. The condition was not met, and therefore we moved on to judgment with only Mr. Simon.
What if the judge was just unsure? The judge said, "Oh, I'm not convinced. I don't know one way or the other, so I'm just not going to address that anymore. Let's move on."
Well, Your Honor, I think if he was unsure, he would have done exactly what he did at the end of the September hearing, which is to say, wait a minute, we need another day of trial, and you folks need to come to court with evidence. This issue, it first came to light that the court did not have sufficient evidence in front of it to determine the validity of the postnuptial agreements at the end of the September hearings. I think it was September 13th. And the court said, okay, we're going to come back October 25th. I want you all to come prepared to litigate the validity of the trust agreements. And it was at that October hearing that this issue related to joinder first surfaced. If the Superior Court were still confused following the end of that hearing, I would strongly suspect that the court would call for another day of hearings, but it didn't. It proceeded to judgment. And critically, I think we know enough about the court's reasoning based upon the colloquy, and there is enough evidence in the record. There's enough with this record to enable appellate review, much in the same way that the court handled the issue for the first time in Graves, as y'all explored with my colleague.
One thing I'm wondering about is, oh, I'm sorry. Well, I was just going to say, one thing this discussion makes me wonder about if if there's any concern that the judge did not make a ruling on the Rule 19 issue. Mr. Simon is the proponent of that Rule 19 motion. Was it incumbent upon him to press the court for a ruling And are there consequences if he didn't press the court for a ruling?
I think it was certainly advisable to ask for a rehearing or to ask for a clarification of the judgment, because once you do have that final judgment, all of the motions that were not granted, it is absolutely appropriate to conclude that they were denied. And I don't think, at least as we see things, I don't think there's any question that we actually have a decision on this issue.
How do you respond to the argument that the trusts have a separate interest here from Mr. Simon because the sons of the family are, I don't know what kind, but are beneficiaries of at least the revocable trust?
Well, let's turn to the revocable trust real fast. I'm going to cite the court to page 7 of the blue brief, where Mr.
Sorry,
Simon
of the what?
of the blue brief, the opening
Okay.
brief in this court. Mr. Simon says, quote, this is as to the revocable trust, Mr. Simon named himself trustee and beneficiary of the GSS trust. And he cites appendix pages 508 through 510 for that proposition. Maybe it's somewhere in the record and I didn't see it, but at least before this court, he has never represented that there is some other beneficiary of the revocable trust other than himself. And so for that reason, along with the fact that he's the grantor of a revocable trust, and he is, as we see it, still the trustee, that's enough to defend the interest of the revocable trust and to bind the revocable trust with this judgment. Now, when it comes
As far as his being still the trustee,
yes, Your Honor.
I guess he testified that he was not the trustee. And he represents to this court that he's not the trustee, if I understand correctly. I asked his counsel about whether we can take judicial notice of his filing in Superior Court that he is the trustee. And counsel had, you heard them, I won't try to repeat them, had an answer to that. Do you think we can take judicial notice of, and how do you respond to his argument that we can't?
So I have two responses. In terms of whether you can take judicial notice, the answer is emphatically yes. This is allowed under the rules. And I specifically cite this, these are documents that are on court view that you can go and you can look at. And this court said in Daniels versus United States, the citation to that is 33 A 3rd 324, that documents on court view are subject to judicial notice. You can go and look at them. In his reply brief, Mr. Simon argues that these cases actually involved different trusts, but that is demonstrably false. And I cite the court to appendix page 700. It's the second page of the property agreement. On that page, Mr. Simon purports to transfer the two properties that were at issue in these other cases that we're talking about into the very same revocable trust that is at issue in this case. So I think the court can take judicial notice of the fact that he has taken inconsistent litigation positions when it comes to his status with the revocable trust. And that should lead to that should arguably lead to a judicial estoppel. But at a bare minimum, it should give this court comfort that an abuse of discretion did not occur by only proceeding to judgment with Mr. Simon.
How do we know that it's the same revocable trust?
Because
By looking at court view.
based upon because it involves the same properties, Your Honor. It involves a trust by the same name, and it involves properties that, according to this document, were put into the very same revocable trust that we're talking about right now.
So we know because of the name. I mean, isn't one of the problems that we don't have the trust?
It would certainly be more helpful to have the trust document, Your Honor, but that is something that is within Mr. Simon's control. If he thought that we needed we needed either of the trust documents in order to adjudicate this case, he had a full opportunity to put them in, but he didn't.
No, we're talking now about this judicial notice issue, which has come up subsequently, right?
I beg your pardon, Your Honor?
This was in connection with whether we could take judicial notice. In other words, you're trying to say what he said in this other proceeding, as to which you suggest we take judicial notice, is flatly the opposite of what he has said in this proceeding.
Correct.
So for it to be flatly contradictory, we need to make sure we're talking about the same trust, right?
We do need to make sure we're talking about the same trust, Your Honor. But I think there is sufficient evidence in the record and on the face of the documents to give you comfort that we are talking about the same trust. In order for it to be different, Mr. Simon would have, sometime in the intermediary, would have literally had to create another revocable trust by the exact same name and transfer the exact same two properties that we're talking about right now into that revocable trust. That's a tough argument to accept, Your Honor, and there's certainly nothing in the record that would support that.
Can I ask you about an argument, the paragraph that begins at the end of page 40 of your brief, and then it segues with footnote 3 of the reply, where you seem to be saying, you know, if this was a mistake, a failure to join, then it doesn't matter so much because this judgment isn't binding on the trust anyway, and it can come up in some collateral litigation. Is that your stance?
Absolutely not. That is, I'm quickly taking a look at page 40 of my brief, but I do not believe that is a position to take, and that I took in my brief, and that's certainly not the position I'm taking right now.
I could see why he read that paragraph the way he did in his footnote 3, and so I just want to get a clarification, because what you say, and it's mostly at the top of 41, is, you know, the court only entered judgment against Gary Simon. If the Superior Court should have included the trust, you know, that doesn't deprive it of authority to act. I mean, it sure sounds like what you're saying is, you know, that's just another matter entirely that can come up in some collateral litigation, and that's how he takes it in footnote 3. So I guess I want to get your alternative spin on what you're trying.
I'll clarify my statement right now. The judgment is against Jerry Simon, but that judgment binds the trust. And if I may, I'd like to unpack that trust by trust. For the revocable trust, he is the grantor, the beneficiary, and arguably the trustee. Wearing either three of those hats, any three of those hats, the judgment against him binds the trust. When we turn to the irrevocable trust, honestly, the easiest way to affirm the judgment and take care of the irrevocable trust is to find that they do not have an interest in this litigation. It's undisputed that they did not sign either of the contracts. They're only mentioned once in the property agreement, and the property agreement on its face does not directly vest any rights in the irrevocable trust. But even if you were to find that the irrevocable trust had some kind of interest in this case, and I'm not sure what it would be, it is nonetheless bound by the judgment because it had aligned interest with Mr. Simon. And I believe there's been some wishy-washiness about this, but the beneficiaries of that trust are actually the children. And I'm citing to reply pages 14 through 15 and appendix pages 418 through 19 for that proposition. The reason that matters is because you have the parents, these are minor children, and you have their parents litigating right here. The parents and Mr. Simon are adequate proxies for the children, and that is enough to litigate any interest that the irrevocable trust might have, and it would become res judicata. So I do want to be clear about that. Where this judgment should not be subject to collateral attack. It should be res judicata of these issues.
I think I might agree, counsel. Kind of my hang up is whether or not we're the ones to say that, or whether or not that's a determination to be made in a collateral proceeding.
Well, Your Honor, as much as I hate to say it, and I don't think this court has any way to stop Mr. Simon or these alleged trustees from going out and trying to collaterally attack the judgment. Right. But they wouldn't have a legal leg to stand on for the very reasons that we're discussing right now.
Okay.
Well, one thing I wonder is whether it wouldn't be in Miss Smith's interest, perhaps, to remand this and have her with counsel in tow this time, resolve all this in the Superior Court so that all the loose ends were tied up, as it were. How do you feel about that?
I just don't think that's necessary, Your Honor. I think to the extent there's any ambiguity or loose ends, I think this court can address it. You have a decision, you have a record, you have the law. I think you can easily craft a decision that would address any lingering issues that are out there.
Well, now, when you say that because Mr. Simon was the grantor beneficiary and arguably, let's assume he's not trustee, of the revocable trust, and therefore any judgment against him binds the trust. The judgment terminates various contractual rights that the trust has, and it may affect the trust's ability, for all we know, to carry out some obligations that it has. Now, maybe Mr. Simon is not in a good position to make that latter argument because we haven't seen the trust agreement, but I'm just positing this for the sake of understanding this. Why is it necessarily the case, or what law do you cite for the proposition that this agreement, because it binds Mr. Simon as grantor and beneficiary, thereby binds the trust? Or maybe I'm confusing what the judgment requires. No, I don't think I am. The judgment terminates various arrangements. And so why is it that the trust, which might say, look, we relied on those arrangements and for various purposes, is bound by the agreement, even though it wasn't a party? Sorry for the long-winded question.
That's all right, Your Honor, and I'm thinking best of how to answer that. I think I think there's two key things to point out, which is number one. I'll come back to this issue. These are his trust. It's not as though we're dealing with some complete stranger to this universe of litigation. This is the Jerry Simon Revocable Trust. That dovetails into the second issue. It's a revocable trust, which means Mr. Simon can snap his fingers, undo the trust, and the property all reverts back to him. The rights all revert back to him. The trustee, my understanding of the trust laws, the trustee does not have independent fiduciary duties to the beneficiaries in the same way that you would have with an irrevocable trust. Mr. Simon is the dictator of that trust. We have him right here. He's the signatory of these contracts. That's another important thing to point out. The people who signed these contracts, all of them, the Superior Court heard from them. And I think that I see my time has expired, and unless the court has additional questions, I'd like to wrap up with coming back to what I think is the key question in this case. What would have been different if we were to have joined these purportedly absent trustees? The Superior Court posed that question to Mr. Simon. He didn't have an answer. The court today has posed that question to him, and respectfully, I don't think he's given an answer. He's not articulated what interest in these contracts these trustees supposedly had, and which they could not adequately defend without first being joined to this action. He has not demonstrated an abuse of discretion, and the judgment below should be affirmed as a result.
Okay, thank you, counsel. Mr. Switzer, we'll give you a few minutes in rebuttal.
All right, I'm going to try to hit the points the best I can. Thank you, Judge Glickman. I thought I had explained it, maybe I hadn't. What would be different? The trustees of the trust have the right to defend and pursue the claims. They have obligations to all the beneficiaries of the trust. What would be different is they would have the right to defend these claims. They have an interest in having these agreements continued and remaining in effect, just they've been in effect for 8 years. I think it's significant.
Why did I say that? Why do you say the trustees have an interest in these agreements continuing?
Because they're parties to the agreements. The trust wouldn't have entered into them if they weren't interested in pursuing them. They entered into a contract. They have the right to have their contracts upheld, just like any other party to a contract.
Okay, well, all right. I hear you. It seems like a funny way to put it, but the trusts are just the servant, as it were, of the people who created them and beneficiaries. It's funny to say, but all right, go ahead.
As time goes on, they have the obligation. So when counsel respectfully said, well, at the time, Mr. Simon was the trustee and he signed it, but he's not the trustee today. And he's not the proper party. Some trusts go on for years and years. The fact that somebody signs a trust agreement and 50 years later or 20 years later, there's an action, there's going to be different trustees. The fact that somebody else signed it before doesn't make them a trustee today. A former trustee is not a current trustee. The other thing that Judge O'Keefe didn't do is he didn't make any analysis of whether it was feasible to join the trust. And that's one of the aspects in the rule and all of the cases. Yet he made absolutely no attempt to do so. If you look at the Raskowskis case, and I'm probably pronouncing it wrong, but the site is in our brief, hopefully you can tell which one I'm referring to. There's a statement. The judge should order that such a person be made a party if feasible. Given the explicit language of the rule, we join the federal courts and interpret Rule 19 to require a trial judge to order whenever possible. There was no attempt to determine whether it was feasible to make these trust parties. Of course, there's
That's
not.
an interesting point. So in other words, do you think that even if Gary Simon was a perfectly adequate person to protect the trust interests, and so that we can in effect say we're satisfied, no harm, no foul. Nonetheless, we can't get there. That's not good enough. If it would have been feasible to join the trust, is that your argument?
All the
Do you
cases-
have? Do you know? Is that correct law?
Well, the Raskowskis case has not
Yeah.
been superseded based upon my Westlaw research last week. So that is, and again, that appears at page 21 of that case about the requirement of making a party that's feasible a party and require the trial judge to do so whenever possible. That's at, I'll give you a better site, 589 Atlantic 2nd, page 21. It's a 1991 case in the brief. And that was never done. The analysis was never done by the court. Hitting some of the other points regarding whether there was testimony, who were the beneficiaries of the revocable trust, appendix page 488 through pages 489, Mr. Simon identifies Darren and Derek, that is the party's children, as beneficiaries. And he also, that's where he testified that he was the trustee, was no longer the trustee. With respect to the argument that the trust is revocable, it is revocable, but it was not revoked at the time of trial, and there's no evidence it's revoked now. If and when that may change, but at the time of trial, and I have no reason to think it's different today, that trust is not revoked. It is still a living trust where trustees have the obligations to the beneficiaries. Sometimes trustees create a revocable trust because they become disabled later. The grantor would have no ability to competently manage his or her affairs or make any decisions. So effectively, they can no longer revoke it, but the trustee still has an obligation to protect them. People use revocable trusts in estate planning all the time and appoint their adult children to manage their affairs without having to go through powers of attorney and probate and all of those things. It's a very I'm going to represent it's a very common vehicle for general estate planning. I'll leave it at that. I think I've hit the points in rebuttal. Unless any of you have any questions for me, I don't have anything additional to add other than, as I said, I think Judge O'Keefe wanted to reverse engineer this based upon his comment that he'd really like to create peace and really would like to be done. Sometimes it's just not simply possible to separate everything. And I think he got to an outcome that the law couldn't quite get him there yet. Perhaps in a different forum, when the parties are joined and it's addressed, they may get there. Thank you.
Okay. Thank you, counsel. We appreciate hearing from you. The case is now under advisement.
Thank you. Leave, right? Leave the meeting?
Yes, you may leave the meeting.
Okay, thank you, folks.
Bring in the next council.
Yes, you may. Okay. I think we're still waiting for, here we go. Good. Council, good morning, if it is still morning. We appreciate your patience. This is the case of Norman Glasgow versus Command Management. Counsel, Mr. Kiernan.
Good afternoon, Your Honor. May it please the court. I hope everyone is well today. The reversible error in this case was that the trial court went behind and undermined not one, but two jury verdicts, the one in the HCP case and the one in this case. At the end of the HCP trial, that jury was asked to decide how much of the money should be paid back to HCP. And the jury came back, as the court knows, with a detailed party-by-party, count-by-count breakdown about the money exchanged hands between the HCP entities and the 247 entities. That determination by the jury in the HCP set the ceiling, the upper limit on what IRT Glasgow owed to anybody associated with the receipt of that money.
Counsel, can I just ask, the HCP jury verdict said all the proceeds go back, right?
Essentially, right.
Okay.
It said, I mean, to clarify, the 5.1 million that was involved in the ground lease set,
Right.
all of that. That's why there's
The entirety of the ground lease proceeds go back to HCP.
Right, and that's why that verdict was then split, $1.7 million from these 5 defendants, $1.7 million from these different defendants, not including IRT, and $1.7 million from these other defendants, and then obviously the punitive damages as well. But it's the full 5.1 that was distributed, it was paid to Square 247 associates that it then distributed to the 5 members. And that verdict, Your Honor, was premised on the conclusion that the money belonged to HCP, not to the Cameliers. Bears repeating. Everyone agrees that that money ultimately belongs to HCP, not the Cameliers. The Cameliers in their current brief, page 15, acknowledge that. So that being the case, the trial court here entered judgment against Glasgow, premised on an argument that the money didn't belong to HCP, that it did somehow belong to the Cameliers.
Now, counsel, I've got a tough time with this argument, so help me out with a hypothetical.
Mhm.
Let's say I rob a bank. You and I rob a bank together. I take $1 million. You're the getaway driver. I run out and I give you $500,000. And later on, I get caught. And I don't want to rat you out. So, and they're feeling generous. So they say, if I give back the $1 million, everything will be fine. I say, fine, here's the $1 million now. That is the agreement. All of it needs to go back. Are you saying I wouldn't have an unjust enrichment claim against you for the $500,000 I gave you because it was never properly my money?
No, I think the hypothetical misses the key element of this case, which is that the HCP jury had gotten the full flavor of what these transactions involved. And they said $1.7 million of this is associated with the breach of the partnership agreement and is jointly and severally with these 5 defendants. And as to all, because IRT was named in all the counts, could have been found responsible for all of those counts. The jury very specifically carved IRT out of the other liability because of the evidence in that case, namely that Chris Camelier controlled IRT, that he had acted along with his brother wantonly and willfully in violation of their rights. And so
okay, let me stick with the hypothetical for a second then. Let's say that you were the getaway driver I gave him $500,000 to. Let's say you didn't know anything about where that money came from. You thought it was, honest money that I got off a real estate investment. So now a jury couldn't find you liable for anything, but couldn't I still get that back from you as a matter of unjust enrichment? And this just goes to your standing question of whether or not the money needs to rightfully be my own if I've conferred it upon you. I tend to think conferring it upon you is enough, even if it was ill-gotten goods.
Actually, Your Honor, I'm not trying to quarrel with your hypothetical, but I think it is sliding between the 2 cases in the following sense. In the first case, the HCP case, the jury was asked of the money that was paid to the ground lease, who was responsible for paying it back to HCP? That answer gets resolved. Second case was who's responsible for paying for the settlement agreement to resolve it. So using Your Honor's hypothetical, if the bank says, if your hypothetical, I don't like the bank robbers, but we'll stick with it. In your hypothetical, if the bank says, as long as Robert X pays me back my $1 million, I'm fine, we're done. Does that bank robber have the right to unjust enrichment from the getaway driver? Am I understanding the?
Yeah, that's right.
The hypothetical.
I have unjustly enriched the getaway driver. He has kept it under the circumstances. It's unjust.
And it's not my money in the first place.
Yeah.
Right. It's not my money. Okay.
Right.
Again,
It's the bank's money.
But I think you still may be respectfully walking back and forth between the 2 concepts, which is, in your hypothetical, the robber has paid on the getaway driver's behalf the money that the bank is entitled to. So if that's the theory, then you've got a more traditional contribution or some sort of indemnification between the two of them. You paid my share. That's different than saying I'm entitled to collect from you the money I wrongfully got from someone else. That's not the unjust enrichment. If the theory is you paid something on my behalf, as we can talk about with the settlement agreement in this case, that's a different hypothetical. I mean, that's a different issue.
Let's focus on the initial 1.7 million payout as the unjust enrichment, as things turned out to be. So you're telling me you want the measure to be the amount of your judgment that they paid off in settling the I mean, I understand you have a standing argument that precedes this, and you'd rather be on the hook for nothing. But assuming we go down the unjust enrichment road, you think it should be the amount of your liability that they extinguished. They think it's more like, well, if we didn't have this three-way agreement that we thought we had, then you should give back the $1.7 million that we just conferred upon you for no reason at all. That was unjust. Makes some sense to me.
Respectfully, there's two parts of that, Your Honor. First of all, the receipt of the money from HCP came into Square 247 partnership and was distributed pursuant to the terms of a partnership agreement. It came in through a contract. If that distribution was wrong in some way, it's got to come back through the contract. It doesn't come in through the side through an equitable agreement. There's contracts involved here. And it didn't give Judge Totoro in this case the right to go behind that and say, forget the contracts. Because recall, Your Honor, when the judge first dismissed the unjust enrichment count before the verdict, she specifically said, this money didn't come from the Cavaliers, and there's a partnership agreement. So that's why they don't have unjust enrichment.
She ultimately said that your client was not part of that partnership agreement, or they weren't part of the partnership agreement right up until the proceeds were distributed. So the unjust enrichment theory flows either from them directing the $1.7 million to you or ordering you back into the agreement for absolutely no consideration whatsoever, thereby indirectly conferring the $1.7 million onto your client, Mr. Glasgow.
And Your Honor, that's just factually not what happened, because at the time of the ground lease being
I'm sorry, just to be clear, are you saying that's not what the trial court found? Or are you saying the trial court found it and it was wrong?
I'm saying when the trial court found, and she found it alternatively, it's both that IRT was in the partnership and wasn't in the partnership. There's no dispute that when the ground lease was sold and the proceeds came into Square 247, that IRT was in that partnership. That's the whole premise of the first case. They wouldn't have been found liable for breaching the partnership agreement if they weren't in the partnership. So there's really no dispute about that. And the judge's finding to the contrary in this case is without foundation. And it's in fact contrary to both the HCP verdict.
Did you make an argument in this case that the prior HCP verdict precluded that factual finding?
Included which factual finding?
The factual finding that whether or not IRT was part of the 527 agreement at the time the proceeds were paid out, that you're saying the HCP jury necessarily found that IRT was part of that agreement. Judge Totoro said, I actually don't think so. Did you make an argument that she was precluded from making that finding based on what the HCP jury verdict found?
I believe we did. I recall the sequencing here. The post-trial, at the time the post-trial filings were made, the post-verdict filings, I should say, were made, IRT wasn't even in the case and the unjust enrichment counts were out of the case. So there wouldn't have been an occasion at that point. But as soon as it was raised again, we absolutely argued that that was not correct, because there wasn't a dispute about it being in the partnership, right? That was not in dispute until, respectfully, Judge Totoro made it a dispute after the fact. And what happened after the fact, Your Honor, was that the whole concept, the whole atmosphere that there's a verbal, non-written, three-way sharing agreement just permeates the case. To go back to your hypothetical involving the bank robbers, underlying that is the assumption that we've agreed that we're going to divide things in a certain way. And
no, it's not. It's not based on any prior agreement. It's just based on what I gave you.
Then I think in your hypothetical, the remedy is a contribution remedy. And we have said, and Mr. Glasgow in real time said, I will contribute my percentage reflecting the amount of my obligation to HCP that the HCP settlement agreement is resolving. He in fact offered to pay more than his probable share of that judgment. So
Mr. Chairman, I'm sorry. I apologize. I thought you were stopping. Go ahead, finish.
No, I'm fine. Thank you, Your Honor.
Well, this segues into what I have been wondering about and asking you. But let me ask you a preliminary question. Why was the damages in the HCP litigation on the breach of contract count only $1.7 million? Why wasn't it $5.1 million?
Because the jury allocated the 5.1 into 3 different counts, one for the breach of partnership agreement, one for breach of fiduciary duty, and one involving the note.
Right, I know they did that. Right, I understand that. Why did, maybe when I said why, I should have said, why does that make sense? I mean, this is a breach of contract, and I'm just sort of wondering why the breach of contract damages weren't $5.1 million. And for that breach, the other counts might have also been in that amount too, but I haven't really worried about that.
Well, except, Your Honor, that what was clear in the verdict was that that jury was drawing a specific distinction between the liability of IRT and the liability of the entities controlled by the Cavaliers. And so they said IRT is not liable for breach of fiduciary duty. They're not, and they're not liable on the note. And that was because of the testimony in the case. They knew about Mr. Glasgow. In closing argument, the lawyer pointed to him and said, he's in the courtroom. We don't want anything from him. He didn't do anything. He didn't do anything wrong.
That was in any event a threshold question that
Sorry.
help me understand this a little better. The way I've understood the judge's reasoning on the unjust enrichment count was essentially along the following lines. The unjust enrichment occurs when the other defendant, let's just say the Cavaliers for the sake of simplicity, when the Cavaliers pay the amount of the judgment that IRT should pay, and it's unjust enrichment to Glasgow because Glasgow is essentially the alter ego of IRT. So whatever the Cavaliers paid that IRT/Glasgow owed on that breach of contract count is the amount of it by which Mr. Glasgow has been unjustly enriched. That's how I understand the judge's rationale for finding Mr. Glasgow liable for unjust enrichment. And so I ask myself, well, all right, what is the consequence of that? What is the implication of that for what Mr. Glasgow owes? Does he owe the full 1.7 million, or does he owe one third of the 1.7 million as unjust to the again, I'm speaking for simplicity's sake, to the Cavaliers. Is there anything wrong with what I've just said?
Only it's not, there's nothing wrong with the way you just analyzed it, Your Honor. No, I just clarified this. I think what Your Honor just described is what I would describe as sort of a classic contribution remedy, right?
Well, I appreciate
you pay part of my judgment, and you should pay me the amount that you benefited from me settling your debts, if you will.
Yeah. One place I was sort of going was, what's the difference? How much difference is there between unjust enrichment in this context and contribution and equitable subrogation, if you want to talk in those terms? And I'm not sure I've worked that through. But in the end, why is it that the right result shouldn't be, well, a preliminary question. If that's the theory of unjust enrichment, is it true that the unjust enrichment to Mr. Glasgow is only a third of the amount that he received? Because after all, the Cavaliers could say, well, it's not necessarily clear that if we had all divided up that breach of contract component of the total damages, that's all you would have contributed. I'm not sure how this would have all worked, but
Okay, and, I'm sorry.
that's the direction I'm going.
And when you address that, can you address the added question of whether or not you were also jointly and severally liable to put the proceeds of the sale into a $3.5 million trust? So Judge DeToro says, if anything, the starting point for that analysis is 3.5 and not 1.7. If you can address that on top of Judge Clickman's question.
I will, Your Honor, and it comes back to the shape of the the HCP jury verdict. So a classic look at this would be, but just hold the HCP jury verdict for a second. We're settling that liability. To what extent did IRT, Mr. Glasgow, benefit? He benefited by being relieved of the obligation to pay his share of the judgment that was entered against him, which, as we explained in our brief, is probably somewhere south of $500,000. That is a fifth share of the $1,767,000 judgment, plus some component for the attorney's fees. Okay, so if you do the math, his total liability is, call it, south of $500,000. That would be a classic contribution remedy. I paid it on your behalf. You need to pay me how you benefited. What Judge DeToro did was she reached back before the HCP settlement agreement and went back to the original transaction and said how you were really benefited was by getting into square 247 in the first place. And at trial in this case, the Cavalier said, well, the only reason he's in square 247 is because we had this three-way sharing deal, this Three Musketeers agreement. And in their current brief on page 27, they refer to it, well, he got in as a matter of fairness. It's the same argument, which is that there's some sort of oral agreement or understanding that dates back 35 years under which the parties agreed to do this. And
counsel, if I could just interrupt, it's not the same. It's not the same argument. It's not the same argument because under one view, under their contractual claim, the argument is we had a valid enforceable contract and that's why we did it. Under an unjust enrichment claim, the theory is we thought we had this agreement that we were going to separate everything in thirds and that's why we gave them the third. But if we didn't, as the jury in this case found, well, then we want our third back.
Respectfully, Your Honor, and I want to be clear as I say this, that's not what the jury found. They asked the jury, did Glasgow breach the so-called Three Musketeers agreement? The answer to that question was no. So when they answered that, they implicitly answered the question you just posed, which is, does Glasgow owe them money for something associated with why he's in these deals? And the answer to that was no.
So I'd taken you not to want to press that argument here on oral argument, but I'm glad that you did. At what point in the closing arguments did you make the argument that there was a contract, but that you had satisfied your agreement under the contract?
Your Honor, so I want to be clear about this. There was no contract. This never happened.
Right.
That's different. That's never happened, and we won on that issue because it never happened.
In what universe might the jury have concluded that there was a contract and you had satisfied your obligation to pay a third of the liabilities?
Well, respectfully, they were asked two questions buried in one is the way I look at it. Is there a contract and was it breached? They answered either or both of those, no. They did answer, by the way, the statute of limitations argument, which means at some point somebody grappled with the question as to whether there's a contract here. And they said, no, that's question one.
No. If you say no, there's no contract, there's no violation of the statute of limitations either.
I'm fine. I'm just saying they must have dealt with that issue. We have been consistent since before day one that this didn't happen and doesn't exist. And what our argument has been, it has nevertheless left this atmosphere hanging over all of that, especially the post-verdict work, that somehow there was a sharing agreement, that somehow there was something other than the partnership agreements, other than the contract documents, that controls the relationships between these parties such that the court can now reach behind and say, when you got the $1.7 million from Square 247 Associates, it was somehow tainted with this understanding that you were third party.
Sure. No. So these are just, I don't know why you're conflating the two things because they're totally different. Under one question, was there a contract for this 1/3 sharing? And I think the jury spoke quite clearly that the answer is no. That was your argument. There's no alternative view of the jury's verdict. The second question is, did they pay you $1.7 million under some mistaken understanding that they had an agreement, totally separate question. That's not looking behind the jury verdict. That's just saying the only reason they would have given you $1.7 million for essentially nothing is they thought they owed it to you. They were wrong.
Respectfully, that's not the record of what happened about when both IRT and Charles Camelier were out and then back in. There was actually a business transaction. There were documents reflecting it. I know now that they lost on the argument that it was the Three Musketeers agreement, they've sort of said, oh, it was out of fairness or there was no other consideration, but that's not the record in this case.
What is the record? What did you confer upon the Cameliers to get your third interest back in Squared 527 just before the sale, or to get a direct payment of $1.7 million of the proceeds of that sale?
Well, Mr. Wilner testified about the sequence of the transaction involved, and it's in the record, about the dealing with the notes, dealing with this was before the ground lease was sold for the position both IRT and Charles Camelier had in this. But it's not, Your Honor, respectfully, it's still at the point, and maybe we're back to our bank robbers fleeing the scene here, that somehow it was the Camelier's money to give to somebody. It wasn't. It was HCP's money, and the HCP jury said, and IRT, you are responsible for paying us back X amount. You and these four other defendants owe us $1.7 million of that. That does not give the Cameliers a free-ranging commission to then otherwise try to adjust the accounts, unless they get it through the Three Musketeers agreement, which this jury said they don't. I see my time's up. I did need to reserve 2 minutes.
We'll give you a few minutes in rebuttal.
Thank you.
Mr. Crowley? You may proceed.
Good morning, Your Honor. So may it please the court. My name is Daniel Crowley, and I represent the appellees, Charles Camelier, F. Davis Camelier, and Caman Management. I think what we see in this case is that Mr. Glasgow does a lot of work to make it seem far more complicated than it really is. It is true that we had a breach of contract claim for this overarching agreement, but we also had this unjust enrichment claim. And the unjust enrichment claim was about the money that was received in 2005. It wasn't about the payment towards HCP in 2011. And we proceeded to the court, as the courts always do, with the legal claims and the equitable claims. And there was a jury trial on the legal claims, and the parties provided their proposed findings of facts and conclusions of law. There's nothing unusual about this. When the jury came back with its verdict that there was no breach of contract, they didn't find that the Cameliers weren't owed any money. They just found there was no breach of contract. The judge's decision didn't contradict, eviscerate, or overrule the jury's verdict at all. The two are entirely consistent with one another. And there's been a lot of argument, both in the briefs and here today, about the breach of contract claim and the Three Musketeers agreement, but I think Your Honors are correct in sort of separating the two here, because the court's basis, the trial court's basis for finding unjust enrichment was, as Judge Deal had said, that either Mr. Glasgow was not a partner and he received the money, or he was a partner only because the Cameliers brought him in. And every time that Mr. Glasgow raises an argument that assumes that he, not actually he, but IRT is a partner, and that's an important, significant distinction there. But when he argues that he received the money because IRT is a partner, he's ignoring the central holding of the judge's decision that doesn't matter. Because
but the HCP jury verdict certainly found that IRT was part of that agreement, right?
The HCP found him liable for breach of partnership agreement. That's true.
And Mr. Kiernan argues that they pointed that out to the judge below and basically said she was stopped from reconsidering that factual finding.
I don't believe that's an argument that was made before the Judge Turturro in the trial court. What happened was, when we provided our proposed findings of facts and conclusions of law, the defendants, the Glasgow and IRT, didn't address unjust enrichment at all. They didn't mention it in their proposed findings of fact, so now it's not actually in the appendix, but they addressed it for the first time in their reply. And they raised a number of arguments. They did claim that Mr. Glasgow was a partner, but it was not based on the HCP verdict. It was based on the tax returns and testimony at trial and things of that nature.
Well, I might have been a little unfair to Mr. Kiernan's argument. I think his backup was that if they didn't make the estoppel argument below, it was some unfair surprise, because nobody was doubting IRT was part of the Square 527 agreement, as the HCP jury obviously found, and Judge DeToro manufactured that without being asked, and so they never really had a chance to respond. I take that to be his backup argument. Do you want to say something about that?
I would absolutely disagree with that. That's been our argument throughout the litigation below, was that IRT was not a partnership. And we addressed it, Your Honor was asking about the transaction that got him back in and the consideration. And the way that it worked was that in 1999, the partnership interest was transferred to CanMan, but so was the liability on the note. And that was the consideration for that transaction. And when it came back, or it didn't come back, Mr. Glasgow just received either the money or the partnership interest without the liability on the note. And when Your Honor's asked about the HCP verdict, that's part of the explanation for that, I think, is that CanMan was still holding the note, and that's why only F. Davis Camelier was found liable for breach of the promissory note. And really what the jury had done was take the whole loss and divide it amongst these three claims. And when you look at that breach of promissory note claim, for example, it's for $1.7 million. The promissory note was originally $4.7 million, had been divided three ways in 1999, and it was only 1.5. So it's clear what the jury really did was require the return of all of the money and then split that amongst the three claims. But that informs a little bit as to how the judgment came the way it was.
Yeah, I want to ask a question that I think goes back to something Judge Glickman was talking about earlier. Let's assume, just for the sake of argument, that the HCP jury finds IRT not liable for anything. They're not on the hook for breach of contract, fiduciary liability, fiduciary breach, or breach of promissory note. Do you still have the same unjust enrichment claim, or is it tethered to your paying off their liability under the HCP jury verdict?
We would still have an unjust enrichment claim because the facts remain that when the money came in for the sale of the ground lease, $1.7 million was paid to Mr. Glasgow that he admits that he had no right to. And the Cameliers paid it back.
I want to press you on it for a second, because that's not quite how Judge DeToro thought of this, though. She said the 1.7 million payout, that was perfectly just right up until your client, right up until Mr. Glasgow didn't contribute his share of the jury verdict. She says something like that. And if the jury verdict were 0 against him, I take it her line of reasoning would be out the door. So did she just get a little tripped up on that? You're saying that nothing hinges on their paying Mr. Glasgow's share of the HCP verdict, right?
The judge's opinion did, but you're asking about an alternative universe where IRT was not found liable. And in that case, I think we would still have a claim. It would be characterized differently because the judge's decision was based on the payment of that claim to some degree. It didn't matter on the amount of the claim. And that's an important point, is that it doesn't matter what anyone's the quantum of liability towards HCP, whether it's the Cameliers or Mr. Glasgow, doesn't really matter. The judge's decision wasn't that we're entitled to unjust enrichment because we paid this much of Mr. Glasgow's liability. It was that Mr. Glasgow received $1.7 million that he admits he has no right to, and then he refused to contribute. And it doesn't matter how much he refused to contribute or how much he should have contributed. His refusal to contribute made it unjust for him to get the money in the first place. And that's why the measure of damages is $1.7 million, because unjust enrichment is meant to disgorge him of the profits. And that's the Pert case, the Kramer case, and the restatement. They're all cited in our brief. They all talk about taking back the benefit that the defendant had received. And that's
so under that analysis, if I'm following you, then really the fact that the HCP jury carved up the damages in the way it did is irrelevant.
I think it is absolutely irrelevant. And as much as Mr. Glasgow reminds the court that he offered to pay some portion of liability, he didn't pay anything. He didn't pay a dime. He says that he would have, but he says that he would have if he also got a release from the Cameliers. So he didn't actually offer to pay any liability. He offered to settle a claim with the Cameliers. He didn't pay a dime towards that judgment. And it doesn't matter how much he was owed, how much he owed under the judgment. The Judge DeToro, under her rationale, was that he received this money and then he turned his back and said, I'm not responsible because my trust doesn't have any assets. And the judge found that to be on unjust enrichment and required him to pay back the benefit. If the court were to lower the judgment to $400,000 or whatever Mr. Glasgow now claims he would be liable for, he still walks away from this with $1.3 million that he admits he had no right to.
I
Well,
ask
wait a
if the
minute.
fact,
Let's go slow here. I'm having a little trouble following this. Suppose Mr. Glasgow had never been in this picture and it had just been IRT. And the verdict had, and when the money came in on the sale of the ground lease, the $1.7 million went to IRT. Now, the IRT was a partner in the deal. It was in, if I understand correctly, and it had a contract with HCP's predecessor. And so IRT was liable to repay that $1.7 million. It was, you could say it was unjustly enriched, but this is covered by a contract. There was a breach of contract. Now, if this had gone to a jury verdict, as it did, and we had this verdict now, and IRT paid only one, whether it's 1/5 or 1/3, we can talk about that later, only its proportionate share of the $1.7 million that was awarded on the breach of contract count. Would you say that the Cameliers could go to IRT and say, well, you got lucky because you didn't get tagged with the other counts, but really you did receive not just a portion of that $1.7 million, but all of it. And so you should pay the rest of it that you didn't pay to HCP to us as unjust enrichment. Would that be right? I don't think so.
Well, Your Honor.
And if that's not right, then I don't see why the alter ego of IRT, which ends up pocketing the money instead of IRT, which is just, as I say, an alter ego, should be in a different position. That's why I say I can see, I certainly agree, Mr. Glasgow received money he shouldn't have gotten. That was from HCP. I don't understand why the jury was allowed to give the verdict it did. That's another matter. But we are where we are. And to me, it's looking like, to the extent that that your clients have a claim against Mr. Glasgow for unjust enrichment, it's the same claim they would have had against IRT, I suppose, for unjust enrichment, if IRT didn't pony up at all. It would be for the proportionate share of the jury's verdict against IRT and the others. Everything else sounds to me like it might, and I thought it was a third. I'm not so sure I'm convinced it's a fifth, but that's another issue. Why is it, and that's what I thought was the judge's reasoning in terms of why there was unjust enrichment, in terms of why the Cameliers had an unjust enrichment claim against Mr. Glasgow. Now, maybe I'm misunderstanding the whole deal, but why don't you respond to what I just said?
Well, in your scenario, Your Honor, you're assuming that IRT had a rightful interest in that money independent of the Cameliers, which is not what happened here. Because even if IRT was a partner at the time, IRT was only a partner because the Cameliers brought him in, gave him back in right before the time of the sale. Because IRT had transferred his interest away to CamAn in 1999. So starting from the premise that that IRT was a partner, he's already been benefited by making him a partner. And he's been benefited by $1.7 million because that's the value of the partnership that they gave him. So it doesn't matter whether he was a partner or not, because if he was a partner, then the benefit was the transfer of the partnership interest or nothing.
Is this the theory under which unjust enrichment was this is not the way I conceived of it, frankly.
Your Honor, this is absolutely my understanding of the judge's decision, and it's at pages 360 and 361 of the appendix. And what she says is that she runs through a number of ways in which the Cameliers benefited Mr. Glasgow, but she finds one way that was unjust. And she talks about the 1.7 million in 2005 became unjust when Mr. Glasgow refused to contribute to the settlement or to the HCP verdict, or however you phrase it. And the important point there is that it's the 1.7 million that was unjust. It became unjust at a later date. But what she found to be unjust was the original payment. And what happened after the original, because in her original decision, the August 31st order, she awarded, I think, a third of the 1.7 million. And
I agree it was unjust, but the reason it was unjust was because it was a breach of the contract with HCP. That's my thinking. And so, but HCP has a contractual remedy.
HCP had
The only reason that the Cameliers have any claim, I mean, look at it this way. Suppose the Cameliers had said to IRT / Glasgow, you know, we had to pay $1.7 million on count number so-and-so for breach of fiduciary duty, or the other count for failure to repay a promissory note or whatever. Well, we'd like you to contribute to that too. It's unjust for you to have kept that. You were in this with us. All of this strikes me as an expansion of unjust enrichment beyond what the way it should work. I mean, the unjust enrichment I thought was the unjust enrichment for which the Cameliers can get recovery. I thought was the extent to which they unjustly enriched IRT. And at the end of the day, given the jury verdict, it seems like they unjustly enriched IRT by a share, whatever the fair share is, of the breach of contract damages.
But that's all focusing on the benefit that Mr. Glasgow or that the Cameliers conferred by settling the lawsuit. And what the court focused on was the benefit that he got in 2007. So at the end of the day, as we sit here today, Mr. Glasgow has $1.7 million in his pocket. Had he not received that money, it would have gone to the Cameliers. And the Cameliers would have used that money to pay back HCP.
It would have gone to HCP.
Because HCP has been satisfied.
We hope.
HPC, it's not their money anymore. They've been satisfied. The Cameliers paid them back. They paid them back not only for the money that they received out of the sale, but they paid them back for the money that Glasgow received from the sale and that he still has today. And
So
that's
does
why,
this undo the results of the jury verdict in the HCP litigation? I mean, the jury did, allocate this.
no, because this is a claim for unjust enrichment. The jury made their decision based on different claims between different parties.
Can a factual question, and hopefully Mr. Kiernan's listening, so he might be able to answer if you can't. What was the rationale behind the HCP trial judge's decision to put a constructive trust only on 2/3 of the proceeds? Why? I mean, the constructive trust in the HCP litigation, I would have thought would have been the entirety of the proceeds, 5.2 and some change, whatever it is. But instead, she put in a $3.5 million constructive trust on the proceeds, representing 2/3 of them. Why?
I don't know exactly why. I know that there were the proceeds of that sale came in two parts. I'd have to do the math really quick. Yeah, they each received about $1.5 million in the initial distribution. And then there was some aspect of the deal that caused an initial payment to come in later. So basically they all got two checks, one for 1.4 million, one for about $300,000 that added up to the 1.7. So I don't know the exact answer to your question, but I can tell you that the 3.5 sort of jives with the 3 times 1.4, 1.5. And I don't, that's
it doesn't. It jives with exactly 2/3 of the proceeds. It's exactly 2/3 of the 5.2. Anyway, all right.
Mr. Crowley, remind me, in the HCP verdict, where the jury kind of did 1.7, 1.7, 1.7, was Command, were the Cameliers found to have breached the contract? Or was theirs a separate,
The Cameliers were found liable on all of the claims.
on all of the claims, but
Except
they
for
still,
breach of- I'm sorry, it was just except for the breach of the promissory note, only F. Davis Camelier was, because everybody else had given their interest to another entity.
yeah, I'm just trying to figure out that allocation, which still doesn't make much sense.
It seemed like a mistake to me, but
Yeah,
By the way, what do you understand the proper allocation of the $1.7 million on the breach of contract count? Mr. Keenan argues that it should be split essentially in 5 parts, and that IRT's share is one fifth. What is your view of that?
right. So I don't, of course, I don't accept that as a measure of damages in this case.
Right,
But
I
as far
understand
as-
that.
But as far as that calculation, I think it's wrong for a number of reasons. And Judge Toro addressed some of them in her order denying their motion to amend. But also the 5 defendants, I mean, the others were defunct corporations or corporations with no assets. I mean, he's essentially saying that he only has to pay 1/5 because he's one of 5, and the Cameliers have to pay 2/5 or 4/5, even though they're only 2 of 5. And the other corporations that were found liable, it was WPI Inc., which is a corporation of which all 3 of them were limited liability partners. So, I mean, between those 2 choices, 1/3 would certainly be the right number. But I'd have to go back to reminding the court that I think the judge's decision was that it was the 1.7 million that was the unjust part of this.
Right, I understand. Okay. Does anybody else on the panel have a further question?
yes, I have a question about the attorney's fees. And why you think that, what was a trial judge, under which agreement could there have been attorney's fees and for what?
So she awarded attorney's fees to us for under 2 contracts. One was the HCP settlement agreement because IRT filed a counterclaim for breach of the HCP settlement agreement, claiming that this no obligations clause barred this lawsuit entirely. That was their claim.
Mhm.
So when she granted directed verdict in the Camelier's favor on the breach of HCP partnership counterclaim, then we were the prevailing parties in an action to enforce that agreement, and therefore we were entitled to fees under the contract. She also awarded us fees under the IRT trust agreement because Mr. Camelier, Charles Camelier, was the trustee. And once the court determined that he acted in good faith and that Mr. Glasgow was unjustly enriched in connection with Mr. Camelier's administration of the trust, then that was a new source of loss to Mr. Charles Camelier. And under the trust agreement, he was entitled to fees and expenses. So-
His suing the trust was an administration of the trust.
No, he incurred fees while administering the trust.
Well,
When Mr.
but the
Glasgow-
administering is his suing of the trust.
No, his administering, Your Honor, is the unjust enrichment, which occurred before he filed suit. So he was unjustly enriched, and then he had to sue. So the expenses of him writing that cost is yes, his attorney's fees for the lawsuit.
Can I
And
just,
the judge-
on the HCP attorney fees theory, in what universe was defending against their paragraph 16, there's no claims amongst us? In what universe was that a third of your attorney fees?
Well, actually, we addressed this quite at length in our motion for attorney's fees, and there are a couple of cases, the Cudon case and the Sibley case, that list a number of factors that address when a fee shifting provision in a counterclaim might encompass the entire lawsuit. And essentially, it comes down to the fact that the counterclaim was a defense to our entire lawsuit, and defeating it was integral to all of our affirmative claims, not just the the counterclaim, because if
But
they want
that doesn't relate to enforcement of the HCP agreement, though, which is the hook that you need to have in order to be entitled to some attorney's fees.
The counterclaim was an attempt to enforce the settlement agreement. And if that counterclaim succeeded, it would have defeated every single one of our claims. Really, it was, what we argued below was really that it was a defense and not a counterclaim in some ways. In some ways, it was really just a defense to our claim saying, you're not allowed to sue us because we have this contract that says you can't sue us. And the factors that are announced in Kudon and Sibley say that if defending that counterclaim is integral to the whole lawsuit, the issues are all wrapped up together, then you're entitled to all of it. And that's what we actually asked for 100% of our attorney's fees. And I think it was a well-founded request, and the judge ultimately decided to give us a third. But also just factually speaking, and a lot of time, if you were to review the trial transcript, you will see that the defendants spent an enormous amount of time having every witness read through that settlement agreement. They had an exhibit where they took the word parties and they substituted every individual party's name and made everyone read it. And it was an enormous part of the case.
Okay. Thank you. Let us hear from Mr. Kiernan briefly. We'll give you 5 minutes.
Thank you. And I'd like to turn immediately, I guess there was a factual question that Judge Deal had regarding the constructive trust. My understanding is that the 2/3 reflects the fact that one of the judgments was on a promissory note and that was therefore separate from the other one. So that the other two components comprise the constructive trust.
Thank you.
I want to come back to the questions that Judge Glickman was asking, because when I first read Judge DeToro's opinion, the post-verdict opinion, I started reading that that's where the court was going to, and then it kind of does a U-turn. So there's a very viable and frankly, we think apparent, and we've argued it, remedy for allocating if the Cameliers paid the portion of the HCP settlement that IRT or Glasgow should have paid. And whether it's 1/3 or 1/5, there's a number that you can reach to with that. And you could call it unjust enrichment or contribution. There was a contribution claim in the case which got dismissed. The Cameliers never appealed that dismissal. But what threw me, and I think is what tangles up the unjust enrichment analysis, is on pages Joint Appendix pages 355 and 356, where Judge DeToro says that Glasgow and IRT received money, and this is on 355, for an asset, the ground lease, that belonged to the Cameliers, or as the owners of Square 247, or the Cameliers and CamAn directly conferred a benefit by giving Glasgow and IRT a valuable asset just in time for the sale. But then the next page, the judge says that Glasgow and IRT's receipt of these benefits was not unjust at the time. So I want to push back on this notion that somehow it was something for nothing. Even Judge DeToro recognized it's not unjust that he got it, but it was retention became unjust when Glasgow refused to contribute to the settlement. The logic of that would lead you to, if Glasgow, IRT, had paid their share towards the settlement, as reflected in the jury verdict, then there shouldn't be any issue about the $1,767,000 from the first verdict. And that's where I think the court, Judge DeToro, went off the track here, because then there was a sort of a snowball effect of, well, what's the benefit he got? And the case kind of, the opinions kind of torqued into, he got it wrongfully in the first place, when the judge clearly said, it wasn't unjust when he got it. It was only unjust when he basically didn't pay for getting it. And one last point.
Counsel, can I ask you a question about that? Let's just say I paid you, and I understand this is different because it's a dollars to dollars situation. But just imagine I give you $10,000 to show up as a clown at my kid's birthday party this Saturday. $10,000, show up like a clown. And then you don't show up. So if a court were to try to fashion the appropriate remedy, they wouldn't look at your performance and the value of that. They wouldn't say, well, usually you'd only pay a clown $200, so give back the $200. You would say, whatever I paid you for that thing I thought I was getting, but I didn't get, you got to give it back to me, right?
Right.
And so here, I think what the judge is saying is, they gave you $1.7 million. They gave Mr. Glasgow $1.7 million because they mistakenly, according to the jury, thought this was a three-way agreement, and they were just wrong about that. And once you've mooched on your obligation under their perceived three-way agreement that doesn't exist, it's not just that you have to give the amount that they paid to the HCP settlement. It's that you need to give back the thing that they gave you for no other reason other than they thought you were part of that three-way agreement. Okay, so what am I missing?
What you're missing, Your Honor, is that when Judge Totaro then takes it the next step and says, the problem wasn't the receipt, it wasn't what you call the mooching. The problem was you didn't contribute to the settlement. And
right, because it was fine. You know, if you had gone, I rescind. That's
no. But I was going to say, Your Honor, the Cavaliers, after this disastrous verdict in which the HCP jury layered punitive damages on these individuals, they came to Mr. Glasgow and said, "You owe us a third of this," and he said, "I don't owe you a third of this. Here's $500,000 and we'll call it a day. That's my share," because if you do the math, that's what it would have cost IRT to get rid of this judgment that was entered against it once you settle all the contribution and so forth. That's the value of what that settlement was to IRT. And Judge Totaro says in the same opinion I was just reading, by granting this claim, she calls it an indemnification claim, but it's the unjust enrichment claim, the court does not conclude that Mr. Glasgow owes the plaintiffs money, thereby overruling the jury's verdict. Such a result would be unjust. And so I want to come back to, and you can't square that with the results because of the million, think of it this way. The HCP case had one count, just the breach of contract count. And assume that jury came back and said it's $1,767,000 against the 5 defendants, okay? What Judge Totoro's order has said here is, Mr. Glasgow, you should pay $1,712,000 towards IRT's towards this, which is, I did the math, about 96% of the judgment should be against IRT. It is clear that what has happened here is that the judge says, and maybe this court agrees with it, the HCP jury got it wrong. They shouldn't have done it this way. They should have had a count that had all 5.1 million or whatever. But the fact, and this goes back to the opening point I made, Judge Totoro should have left that jury verdict alone. That was the final word on that. And there wasn't an occasion to go back and say, well, you really, when you said there was a judgment for $1,767,000, you really should have made it for the 5.1 or the 3.5 or something else. Because that's not the province of the court in this case. And that shouldn't have been the province of the court in this case. That was a done, settled, literally settled matter. 2 other quick points. On the attorney's fees issue that was raised, as you know from our brief, Judge Totoro treated the definition of capital P parties in paragraph 15 and 16 very differently. So in paragraph 16, where we said that the parties have no obligation against each other, the court said that's not intended to create horizontal relationships among the square 247 people. And on paragraph 15 about the attorney's fees, she said, yes, it does. The same term, the same parties, literally banging up next to each other in the contract. And one final point, if I may, just so that you are clear about where we are. The HCP jury, and maybe contrary to the way the court's thinking about how that should have been done, the HCP jury did not order IRT to disgorge all the money. Okay, it wasn't a disgorgement order. Could have been, but it wasn't. And that jury verdict should have been respected, and it should have translated into IRT has to pay its proportional share to that was paid on its behalf to eliminate its liability, not to eliminate Chris Cavalier's liability, not to eliminate David Cavalier's liability, but its liability. So we think that the court should do, vacate and reverse the judgment that's been entered here, remand for the court to address the issue that Glasgow raised, we haven't discussed it this morning, about Mr. Cavalier's conduct as a trustee. The idea that that claim was moot is just not supported in the record. And one other thing, the court could instruct the trial court on remand to consider or reconsider the Cavalier's motion for reconsideration on the dismissal of the unjust enrichment count under the proper standards for evaluating the unjust enrichment / contribution count focused on the judgment and with due deference to the jury verdicts, not only in this case, but in the HCP case. Thank you very much for your time this morning. Good afternoon.
Okay. Counsel, thank you both. Very interesting argument, and the case is now submitted.
Court is now adjourned.